with you today?
I do. I can send that to Mr. Lebo's email.
Because it's
Thank you,
very
Ms.
hard to get Mr. Cola back here, and I'm sure he wants to try to get all these resolved, and I don't see a purpose of sentencing him on one if he's got outstanding things. So, Mr. Coca-Cola, how long are you gonna be there, do you know?
I'm gonna be up for parole in about 2 months. But with a potential release as early as July of next year. I've been here about 3 years now, so between now and next July, I would say.
All right, thank you.
What did you say the maximum penalty on that charge carried, ma'am? Your
93
Honor,
93 days, sure, sir.
is there any way that we can resolve it all today? I mean,
That's
is
why
that possible?
that's why I'm putting you in a room with your attorney so you can talk to him to see if there's some possibilities in that, okay?
Thank you, Mr. Washington. I appreciate that very much so.
You're welcome. All right.
I'm just-
Mr. Lebo's still here. Oh, there he goes.
Yeah,
All right.
I already have.
Go ahead. All right, the court will call the case of the state of Michigan versus Josephina Brooks, 25S00130, as well as 25S00133.
Tiffany Woods for the people.
Good morning, Your Honor. Good morning, everybody. This is Matthew Mansour, Assistant Public Defender, with and on behalf of Miss Josephina Brooks. Miss Brooks, can you state your name for the judge, please?
Good morning, Your Honor. Brooks.
Thank you. Good morning. We're here for pre-trials in both of these matters.
Yes, Your Honor, that is correct. I know Mr. Lebo has been working with Miss Brooks regarding these two pre-trials. If I can ask on the record, Miss Woods, where we are at with the two pre-trials and regarding any offers.
Yeah, so she could plead guilty as charged with HIDA in the stalking matter with restitution in the larceny case. And I would dismiss the larceny case, and I'm asking for no upfront jail and referral to probation.
Okay, thank you. Miss Brooks, did you have any questions? Did you need to talk to me or Mr. Lebo about this some more, or do you know what you want to do?
I would like to talk to Mr. Lebo some more. We spoke briefly this morning.
Do you want to do that today, ma'am, or do you want some time to think about it and then talk to him? What do you want to do?
Is he on here?
But he just went into a breakout room with someone else, so you can wait, and we'll put when he gets back. It's up to you.
Okay, yeah, if I could speak to him, that would be great.
All right, I'll pass this then.
Thank you.
You're welcome. I take it, Mr. Mansour, you're gonna send him the offer in writing so he'll know what it is?
Exactly, Your Honor.
All right, thank you.
Thank you.
The court will call the matter of the state of Michigan versus Alexander Cronon, case number 23S00315.
Tiffany Woods for the people.
And Matthew Mansour, Assistant Public Defender, on behalf of Mr. Cronon. Mr. Cronon, can you unmute and state your name for the judge, please?
Yes, good morning, Your Honor. My name is Alexander Cronin. I'm the defendant.
Good morning, Mr. Cronon.
How are you?
I am okay. All right, Mr. Mansour, I think this is also a Lebo matter, so I'm getting here, and some of these are pretty challenging. Mr. Cronon's been with us for a while, so I'm not sure where he is. Last time he talked about getting a resolution. I'm not sure if we're still in that same place.
So Judge, the plea offer in this is a DV4A with a sentencing agreement to 1 year of probation.
Thank you, Ms. Woods. Mr. Cronon, similarly to the last person, do you need opportunity to speak with Mr. Lebo about that, or are you ready to go too?
Oh, yes, absolutely. Yes, I definitely need to speak with Mr. Lebo.
Okay.
Thank you.
Sorry, Your Honor. But Your Honor,
No,
I am ready.
The other option is, and I don't need the prosecutor's approval for that, would be that he could plead as charged and just get credit for time served. But it would not be under 4A.
That's correct, Judge, and I believe he wants the 4A, but I'll leave that up to Mr. Lebo and defense counsel to figure that out.
Right. I will pass that one as well. Okay. Mr. Cronin, we'll recall it once you've had a chance to talk to Mr. Lebo. You're third in line to talk to him, as you probably figured out by now. The court will call the case of the state of Michigan versus Kevin Bryant, 25F00045.
What's for the people?
Matthew Mansour on behalf of Mr. Kevin Bryant. Kevin, can you unmute and state your name for the judge?
Good morning, Kevin Bryant.
Thank you. Good morning, Mr. Bryant. We're here for a pretrial in this case.
Yes, Your Honor, we are. I had spoke with Mr. Bryant. Mr. Bryant understands the prosecutor's policy regarding offers, and he would like to set this matter for final settlement conference. I know we've been going a little bit back and forth with the conflict between the Washtenaw County Public Defender's Office, but I have confirmed that there is no conflict and our office will remain on the case.
Thank you. Final settlement conference in this case will be on June 27th, 2025 at 9:30 a.m. with a jury selection of July 11th, 2025 at 8:30 a.m. Bond is continued.
Thank you.
Thank you.
Thank you. We'll see you on June 27th, sir.
Yes, ma'am.
Thank you.
Thank
you. The court will call the matters of Cantaria Cummings. Case numbers 24 FB 1131, 15 S 00122, 21 W 0026955R, and 24 FB 11.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Sorry, Ms. Barnett. Matthew Mansour on behalf of Ms. Cummings. Ms. Cummings, can you state your name for the judge?
Cantaria Cummings.
Thank you. We're here for sentencing on a probation violation. The defendant was in court back on March 31st, and she had a positive test, but it was the beginning of her CCOP, and I'm happy to report that she has not had any more recent positive tests. She's doing well in her CCOP, and she has payments that are due, but obviously I'm more concerned about making sure she continues her CCOP and continues to do well in that. So that's what I'm mainly worried about. I intend to follow recommendation.
Thank you, Your Honor.
Anything else you want to say on behalf of your client, Mr. Mansour?
No, Your Honor, I know it's been a rocky road, but I'm glad to see she's back on track and handling business. I'm happy for her, and we are happy that the court is going to follow the recommendation.
Thank you. Anything from you, Mr. Barnett?
No, Your Honor. Thank you.
Ms. Cummings, anything you want to say?
I did want to speak about the as far as the payments. I was thinking maybe that the bond money that I paid could pay off the whole total.
Let me see. Yeah, you're right, it could. You want us to just do that?
Yes.
Okay. Then we'll do that and you'll get some. I think you're gonna, let's see. I think you're gonna get some back.
Yeah.
I'll have them apply it and return the balance. Please
Okay.
continue to do well in your programming. You look like you're angry, but other than that, you're doing a lot better. So, it takes a while before the anger wears off, I think.
I'm
I
just tired, that's all.
Okay. All right. Well, I hope this helps you, Ms. Cummings, and I hope that once we're done with these things, we don't have to see each other anymore, and I know you feel the same way. We've
I'm
been,
definitely ready for it to be over with.
I know. All right, so I think the way we have it set up right now, we're going to continue on your probation as has been ordered. The plan is for you to see me, to see the agent. You don't even have to see me anymore. You're gonna go see the agent. So as long as you keep doing well, you won't have to see me anymore. You'll talk to your agent about everything. And your hair looks beautiful, by the way.
Thank you.
And I'll give you a court date on July 21st, okay?
Okay, thank you.
July 21st, 2025 at 9 a.m. with the agent. And we will apply the bonds to your court costs. And hopefully, next thing I'll be signing will be a discharge from probation when you get done with everything. Okay?
Okay, all righty.
Thank you. Take care.
Thanks, you too. Have a good day.
You too. Bye. I gotta go through all those, Heather. It'll take me a minute. All right, the court will call the case of the state of Michigan versus Elroy Love, 23 FB 1442, as well as 23 FB 1460.
What's for the people?
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Elroy Love. Mr. Love, can you please unmute and state your name for the record?
I'm Elroy Love.
Thank you. Please turn on your screen, Mr. Love.
Okay.
Thank you. All right, we're here for pre-trials in these matters.
That's correct, Judge. I would just inquire as to the people, whether there are any offers available.
Not at the moment. We're still waiting to discuss it with the victim. I should have an offer shortly, and I can email it over to you once I get that.
Okay. Judge, I guess given that information, would the court be all right passing this matter so I could just discuss with my client what he'd like to do today?
Okay, that's it.
Thank you, Judge.
We'll call the matter of the state of Michigan versus Christopher Jackson, case number 24S00018.
Hey, what's for the people?
Matthew Mansour on behalf of Mr. Christopher Jackson. Mr. Jackson, can you unmute and state your name for the court, please?
Christopher Jackson.
Thank you. We're here today on a pre-trial.
Yes, Your Honor, that is correct. The Washtenaw County Public Defender's Office appears to be conflicting out of this matter, Your Honor. So if we could adjourn this to allow Mr. Jackson to get in contact with retained counsel or private counsel.
I'm sorry, are you conflicting out, or is he hiring new counsel? I'm confused.
I'm sorry, Your Honor, we are conflicting out. It appears we have represented somebody involved in this case.
And so they're going to be reassigning someone to him from the list.
Yes, sorry about that.
Okay. I just want to make sure I understood what was happening. All right.
Poor choice of words for me. Yeah.
No worries. All right, I'll put this over to May 12th, 2025 at 9:00 a.m. So your bond will continue on this case. You understand that you need to make sure that you hear from counsel. Counsel should be reaching out to you, sir. Once they've been appointed, and hopefully they will get that conflict resolved in the next week, so that you'll hear from them in the next week and a half.
Okay.
All right. Thank you.
All right. Thank you. Have a good day.
You too. Bye-bye.
Bye.
The court will call the case of the, let me know when you're ready, I'm sorry.
Hello?
1 second, please. Mr. Jackson, you're free to go. Have a good day.
You too, I
You work now?
Yes.
Okay. The court will call the case of the state of Michigan versus Lamar Jones, 25 FB 1032.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Jones. Mr. Jones, can you unmute and state your name for the judge, please?
Lamar Jones.
Thank you. We're here for sentencing today.
That is correct, Your Honor. Mr. Jones and Mr. Lebo went over the report. We have no additions, deletions, or modifications. We would like the court to accept the recommendation.
Thank you.
Judge, I've also had an opportunity to review the PSIR recommendation, and I'm also also asking the court to follow that recommendation of 24 months of probation. But I wanted the court to know that I also received a community corrections report that the defendant tested positive on March 3rd. And then he was placed on the scram tether. And I don't believe there's been any violations since March 28th through April 14th.
Yeah, that they handled that before we got to the stage
Thank you, Judge.
at the exams. That's how he got put on the scram.
Thank you, Judge.
All right. Mr. Jones, is there anything you would like to say today, sir?
No, ma'am.
Okay, well, I'm gonna follow the recommendation. I am concerned about the fact that today you're given an opportunity to say something and you don't have any apology to give. You apparently,
Your Honor, I really don't know what to do in these types of circumstances. This is my first offense in my whole entire life, so I really don't know what I can and can't say. So, but I went through this before. I am very apologetic of my behavior. What happened was basically because I was heavily intoxicated.
okay. Well, thank you for at least acknowledging that part. I will follow a recommendation. It is the sentence of this court, sir, that you serve 93 days in the Washington County Jail, credit for 14 served. The balance of that time is suspended, so you won't have to do any additional jail time if you follow all the orders of the court, okay?
Yes, ma'am.
You are on probation for 24 months. Fines and court costs in this particular case for a total of $595. You also must pay $30 per month probation oversight fee. You to meet with probation when and where directed, including any and all home visits, weekly phone reports, probation group meeting. And you to attend and complete the Accountable Choices Domestic Violence Program. You may do the Community Corrections Program if you feel like you should do that one instead. You're restricted from having any alcoholic beverages in the house. You're to pay and be responsible for random drug and alcohol tests as requested by the court, probation, or any police officer or treatment provider. You to provide monthly verification of compliance and complete all of your conditions of your probation. You're to attend court reviews as ordered by the court and provide proof of compliance. You must make earnest efforts to maintain legitimate employment. You're to complete an assessment for CCOP within 48 hours. The probation department will give you all the information in terms of who you need to contact to get these things done, okay?
Yes, ma'am.
You're restrained from assaulting, harassing, stalking, threatening, or engaging in any other conduct that would place Monet in reasonable fear of bodily injury. There's no assaultive and threatening behavior with Monet, Faith, or Heaven, or anyone else. No contact with either of those people whatsoever. And there's no going to the residence of either of those people. No use or possession of alcohol, illegal drugs, drug paraphernalia, no being in the presence of anyone using them, and no use or possession of firearm components, ammunition, or other dangerous weapons. Do you understand the sentence, sir?
Yes, ma'am.
You need to contact the probation department tomorrow after 9:00 a.m. They'll go over the contract and give you the phone numbers that you need in terms of who to contact to begin getting the services done, okay?
Where would that be at?
I'm gonna give you their phone number. Do you have a pen?
1 second.
Okay.
I'm ready.
All right, 734
Okay.
483 73 36.
Thank you.
You're welcome. Please call them after 9:00 tomorrow, okay?
Yes, ma'am.
And then I'll set you up for review. And I'll see you back here on July 21st, 2025 at 9 a.m. I'm sorry, 10 a.m.
Okay.
Thank you.
Thank you.
State of Michigan versus Elroy Love, 23 FB 1442.
Tiffany Woods for the people.
Christina Costantino appearing on behalf of Mr. Love. Mr. Love, can you state your name for the court?
Elroy Love.
There's also 23 FB 1460. Sorry.
My apologies, Tiffany Woods for the people.
And Christina Costantino on that case as well.
Thank you. What
Just
would you like to do?
thank you very much for the opportunity to have a breakout room with my client. At this time, we would be asking for an adjournment of the pretrial so that way we can determine what, if any, offer might be made in this case.
And there is an offer. My apologies. I was looking at the wrong page on my notes. So the offer would be he would plead guilty as charged to the domestic violence case with any restitution from the other case, which is the 23 FB 1442 case. And then I would dismiss that case.
Okay.
And sorry for the misunderstanding.
No, that's all right. Judge, will still be asking for an adjournment so that I can have an opportunity to discuss that offer with my client.
All right, thank you. Pre-trial in this matter, does May 12th work with you?
Let me just double check. Yes, that does work.
Pre-trial is adjourned to May 12th, 2025 at 9 a.m. The bond will continue. We'll see you back on that date, sir, and you'll have some time to think about what you want to do about the offer or do some further negotiations potentially, okay?
Okay.
All right, thank you.
Thank
See
you,
you then.
Judge.
You're welcome. I managed to lose my docket in the middle of something, summarizing. Oh. I think he was the last guy that was in it. All right, I'm just gonna do it this way. I'm just gonna recall them all and then you could write down which ones.
That's
they
fine.
were. Okay. The court will recall the matters of Christopher Cocola, all of those matters, please.
I think what's for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Liba for Mr. Cocola.
Thank you. Mr. Cocola, could you state your name again, please?
Yes, Your Honor, it's Christopher Cocola.
Thank you, sir.
You're welcome.
All right, Mr. Lebo, you wanted to talk to your client, and I don't know if you got a chance to go over the discovery with him, etc.
I did, Your Honor. We do have an offer from Mr. Barnett that Mr. Cocola would like to accept, and that would be for Mr. Cocola to plead guilty to a reduced charge in the new offense of disorderly conduct. In exchange for that, the A and the B matters would be dismissed, and I believe he would also be pleading to the DWLS matter. We would be requesting a COBS to a 30-day concurrent sentence, Your Honor, and that's because Mr. Cocola is going to be eligible for evaluation to be released to a halfway house soon, and he tells me that a sentence longer than that would keep him in prison due to the way the Bureau of Prisons handles concurrent sentences.
So he has correctly stated the plea offer. I didn't mean to cut you off, Your Honor.
That's okay.
And I'll leave it in your discretion as to the COBS. I guess I don't have an objection to that. He's been incarcerated for a period of time. This is a relatively old case. The new case, the assault and battery, was simply threats with putting the parties in reasonable fear of a battery. The victims were his grandparents.
I see. Okay.
Your Honor?
Yes, sir.
Yeah, if I could just state, I know I've been no angel in my life in regards to the other stuff, but that was an incident that happened 3-4 years ago.
Mr.
I was like,
Mr. Cocola,
Yes,
you're gonna get
Yes,
a
Your
chance
Honor.
to tell me anything you want to tell me about that,
All
I
right.
think, okay?
All right, cool. Yes, Your Honor.
All right, I'm just trying to get the plea down, because I have a B and a C ticket, but I don't have an A ticket that, wait, let me see. So, oh, I see, so you're dismissing the speeding tickets. Is that correct?
I can dismiss the speeding ticket, and then there's a false info and a DWLS. So I'll be dismissing the false info.
Okay, I got the false info, but then there's two speeding tickets, 19W0038. No, those are show causes.
Yes.
Okay, all right, got it. Thank you. Okay, thank you. All right, thank you. So the problem is in show causes, you can't miss them. Show causes, I can't give him credit for those. Those are civil infractions. So there's that part of the agreement that's still, I think we'll have to still work around. So you're just dismissing the B ticket, and then he's pleading on the C ticket as charged, the DWLS.
Correct.
Okay. So is this a disturbing the peace or disorderly, drunk, obscene, jostling and roughing? What are we doing?
I would propose disorderly. I would propose disturbing the peace, Your Honor, if Mr. Barnett doesn't object.
That's fine. We can do that.
So that one is 750.170. And it carries a maximum penalty of up to 90 days and or $500 fine plus court costs. I will grant the cop request to the 30 days.
Thank you, Your Honor, and then that would be what Mr. Cole would like to do.
All right. So, sir, it's my understanding you're going to be pleading guilty to a disturbing the peace in the 23T00280 case, and count one, the assaultive matter would be dismissed. We do an immediate sentencing today of the 30 days credit time served, so that you wouldn't have to have your potential transitional housing just that would, and then you're gonna plead guilty to driving while license suspended as well. And then the B ticket would be dismissed in entirety, the false info to a police officer. That's your understanding of the agreement, sir?
Yes, Your Honor, it is.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you lower your hand. I went over these rights with you earlier, but I'm gonna go over them again just to make sure that you fully understand. You have a right to have a trial by a judge or a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, any question, any and all witnesses, and you have the right to be a witness for yourself. Or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. And then in addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand these rights?
I do, Your Honor.
Do you understand you're gonna be giving up all those rights and you're not gonna be having a trial of any sort?
Absolutely.
You also understand that there's no automatic right to appeal this decision. So the decision you're making about these cases today, in all likelihood, is gonna stick with you.
I do.
And if you were on probation, parole, or bond to anyone but me, you could be in violation of those probation, paroles, or bonds. Were you on any others other than these cases we have before us today?
I was not.
All right. And if you're not a US citizen, sir, you could have immigration consequences. Are you a US citizen?
I am.
I didn't mean to ask that, but thank you for answering. I'm trying to get used to my new way of doing this. Sometimes I still go revert. I've been doing it the same way for 3 years now. In addition to that, sir, to the charges of this disturbing the peace and driving while license suspended, how do you plead?
I plead guilty, Your Honor.
Has anyone promised you anything other than what we just placed on the record to get you to plead guilty?
They have not.
All right. Has anyone threatened you in any way, shape, or form?
No, Your Honor.
All right. So on or about March 28th, we're going to start with the 280 first case first. On about March the 28th of 2022, were you operating a motor vehicle at the vicinity of 6939 Munger Road? Nope,
I
wrong.
was.
Motor vehicle. Were you at 6839 Munger Road?
I was.
And at that time, did you disturb the peace of Lowell Stafford and Mary Stafford, and the police had to be called?
Yes, I did, Your Honor.
All right. Thank you. I take it you made some threatening actions towards them and they had to call police, correct?
I yelled at my grandfather. I felt like he was mistreating my grandmother, and I probably overreacted. I definitely did. And I'm very apologetic for that. At that time, I was their caretaker, and I probably wasn't in the best state of mind either. So, yeah, it's just good we're getting this cleared up. That's right. Yeah.
And then now for the driving offense, I got ahead of myself on March 26, 2019, very old case as well. Were you at the vicinity of eastbound I-94 and Wyatt Road, sir?
That is correct. I believe 94 would be Michigan Avenue. I don't think Wired runs to 94, but yes, ma'am.
All right, you acknowledge that was in Ypsilanti Township, though?
I do.
And at that time, you were operating in a motor vehicle?
I was.
And you did not have a valid license. Your license was suspended, is that correct?
That is correct, Your Honor. Absolutely.
I find that there's a valid plea for both of these matters. Are you satisfied, Mr. Barnett?
Yes, Your Honor. Thank you.
It's likewise satisfied, Your Honor. Thank you.
Thank you. And as to sentencing, anything you want to say on behalf of your client?
No, Your Honor. Well, yes, I think Mr. Cola did have discussed how greatly remorseful he is for his past actions. In discussing in my conversations in the break room, he's made it very clear that he sincerely is a changed person since he's been in federal custody.
All right, well, apparently we're not picking it up because of whatever whistling noise is sounding in your background. And you probably are not aware of it, but it is making a little whistling noise, which is affecting the equipment.
Would that be me?
Yes, that is you. It wasn't doing it for a long time, but then all of a sudden, when you started talking most recently, it started making this whistling noise. Squealing noise, I guess. Maybe it's a better way to.
Is it any better now, Your Honor?
Yes, it is actually.
Oh.
All right, now you may proceed.
Thank you. I'm not actually entirely sure what I did, but Your Honor, just note Mr. Cole has discussed me how he regrets his past actions, and since his time in federal custody, he's worked on himself. He's completed the residential drug addiction program there, and he's looking forward to living a much better life when he's released.
Thank you. Mr. Kukola, anything you want to say, sir?
Yes, Your Honor. I would just like to basically report to the court that this happened like 3.5 years ago. And, since then, I can happily say that I made a lot of positive progress in the Federal Bureau of Prisons. I've taken this time to reevaluate myself and to truly do everything I can that was applicable to me to, to come home and, I guess, gain and maintain a positive stature within society. I'm looking forward to it, and I won't let you guys down. I apologize for all of this. So, yeah, that's it. Really.
Thank you.
You're welcome.
All right, and case number 23T00280 19W003865C, as well as 21FB1800. It is the sentence of the court that you serve 30 days in the Washtenaw County Jail, credit for time served on each. I understand that the controlled substance use case is a
Your Honor,
yes.
could I ask the court, they have to fax, I mean, they don't have to, but I would much appreciate if they could fax over the resolution of this case to my counselor. I have the fax number here. I think it's called a disposition or something of the case, the final sentence, I guess, is what it is. The fax number is 570.
Your Honor, I did get this information from Mr. Cole, and I can email that to Ms. Ball.
Okay, well, it's 570-544-7223. Thank you, Your Honor.
You're welcome, sir. All right, fines and costs are waived in both in these matters. Sir, as I said earlier, I cannot do anything about 19W003865A and B because those are civil infractions for which I cannot give you time in jail. So you'll still owe fines and costs on those ones. Okay.
What do I do to get them closed out? I cannot get my halfway house unless those matters are closed out.
Speeding tickets?
Yeah, absolutely. And the Federal Bureau of Prisons now, we cannot get halfway house if you have a seatbelt ticket. If you have anything pending, you're not dealing home within 6 to 12 months later. So that's my big dilemma with all of this is those speeding tickets are really causing a calamity in my life right now. I know that's my own doing, but I don't know how to resolve it. I mean, being here, I obviously can't pay a fine.
Mr. Cole, have they told you that the tickets are holding you? My understanding is that they would only be holding you if they were in a warrant status.
No, it's an open case. An open case in the Federal Bureau of Prisons prevents you from going to halfway house due to the fact that I guess you have an open case. I've argued this forever, that a traffic ticket has no bearing on my my freedom, but to them it does. They all have to be resolved. So for all the programming we take, if we've accumulated 365 days early release or none at all, just our standard 6-month halfway house, you're ineligible due to any open citation, ticket, violation, anything.
The tickets are disposed of. You just have fines and costs. So
It's in my PSI. That's the problem. That docket number is listed in our PSIs. Our hands are tied. I mean, I don't know.
how much is owed? Hold on.
And theoretically, what happens is when you have a ticket that you would have just had a fine for, you ultimately end up serving 6 more months in jail for something that's only citable for a fine.
Mm-hmm. Okay. No. Oh, it's actually 20W 003658.
Okay, so the speed.
Yeah,
Okay, I thought you have the list.
sorry, yes.
So that was 34.
So one is 354 and the other one is 234. 588.
Okay.
Suggestions, Mr. Lethal? I mean, I'm just not willing to waive the entirety of these tickets. That's the problem.
I understand, Your Honor. I suggest Mr. Cole would be that we complete today's proceedings and he simply double check to see if those cases are in fact holding him. I'm not sure why a disposed civil infraction that's simply a civil debt would keep him in federal custody. So I'm wondering if there may be some misunderstanding regarding that.
Mr. LeBeau, they actually gave me those docket numbers as some of the cases that are holding me. The problem is it's not resolved. Anything that's outstanding with the BOP, they won't send you to halfway houses. Is silly as that sounds, I guess, for lack of better words. I just.
Status on both 3DC and then the 23-2 ticket. So I'm guessing that there's probably one to mention them.
I think they were in warrant status. Well, I don't know how. It's not in here. We'll do is schedule these for May 12th at 10 o'clock a.m. So you can check on that, sir. There were some tickets that you were in warrant status on, which may have been holding you, but I don't think they're gonna hold you on fines and costs only. You can double check about it on May 12th.
Yes, Your Honor. Thank you, and I appreciate that very much.
All right,
Thank you, Your Honor.
you're welcome.
And Your Honor, I believe the B ticket was going to be dismissed as well.
The ticket is dismissed.
Thank you.
We've already put that on the ticket. That is dismissed, as well as
Thank you.
count one in the other one. All right, we'll see where you are when you come back. Well, actually, is that enough time to get him ready on May 12th? I think so. Mr. Burnett, do you need anything in that?
I think that would be okay. Can Ms. Ball perhaps send me the information as to where the writ goes to? Maybe just email it to me. I can prepare the writ in that amount of time.
Okay, thank you.
A writ in the sense that I'm actually going to come there in front of you guys?
No, just the way you are right now, sir.
Okay, all right, thank you.
Thank you. You're all set, sir.
All right, you guys have a blessed day. Thank you.
Thank you, you too. The court will recall the case of the state of Michigan versus Alexander Cronon, case number 23S0315.
Tiffany Woods for the people.
Assistant Public Defender Davi Lebo for Mr. Cronin. Mr. Cronin, can you state your name, sir?
Alexander Cronin.
All right, Mr. Lebo, where are we?
Your Honor, I did have a chance to discuss the offers provided by Ms. Woods with Mr. Cronin in the breakout room. He has asked me to inquire if we can get a brief adjournment for him to consider these offers.
Okay. The court will adjourn. Mr. Cronin, well, does the May 12th date work for everybody?
That would work for defense, Your Honor.
All right, May 12th at 9 a.m.
May 12th works for me as well.
Thank you, sir. We'll see you then, okay?
Okay, great. Thank you.
Bond is continued. State of Michigan versus Josephina Brooks, case number 25S00130, as well as 25S00133.
Tiffany Woods for the people.
Assistant Public Defender Davi Lebo on behalf of Ms. Brooks. Ms. Brooks, can you say your name, ma'am?
Josephina Brooks.
Thank you. And you had a chance to talk to your client. Where are you, Mr. Lebo?
Thank you. Yes, I had reviewed the plea offer with Ms. Brooks. At this time, we're requesting an adjournment. I do want to have some additional plea discussion with Ms. Woods in the hopes that we can reach a different resolution.
I can do May 12th or May 19th.
Your Honor, I would ask for May 19th.
Mm. Pre-trial is adjourned to May 19th, 2025 at 9 a.m. Bond is continued.
Thank you, Your Honor.
We'll see you then.
Thank you.
You're welcome. You need these? State of Michigan versus Juanita McKay, case number 16S00871.
Tiffany Woods for the people.
Assistant Public Defender Davy Lebo on behalf of Ms. McKay. Ms. McKay, could you say your name, ma'am? Ms. McKay, could you say your name, ma'am?
She's not at a camera.
Juanita McKay.
Thank you. All right, we're here today on a motion to set aside the conviction in this particular case.
Yes, Your Honor. Yes, Your Honor. And I believe Ms. McKay does meet statutory eligibility. She has no prior expungements and no other convictions. Since she has composed a statement regarding her post-conviction activities.
All right, thank you. Ms. McKay, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand now. I have some questions to ask you that, and then after that, you can give me your statement, okay?
Okay.
All right. First of all, ma'am, have you been convicted of more than 3 felonies?
No.
And have you had any assaultive crime set aside?
No.
And do you have any criminal charges pending at this time?
No.
And I think that's it. Now, what is it you would like to say to me about what you've been up to since 2016 when this happened?
Judge, I have been working. I've been with the government, the Social Security Administration, for 20 years. I have not had any type of trouble or anything prior to the 2016 incident or after. It was just a very bad decision that I made at the time, which I totally regret. If I had to do it over again, I would definitely not have done things in that matter. Like I said, I've been working. I have a group called Grassroots that I volunteer with to give out food and different services in the neighborhood of the east side of Detroit. And that's about it. I'm big on family, good mother to my now grown kids, but I haven't been in any type of trouble or anything after this terrible incident, and I regret it fully.
Thank you. And, you completed you were discharged from probation back in 2020, so it's been more than 5 years since you were discharged, correct? And that was in January, correct?
I believe so.
All right. Ms. Woods, anything from you?
No, Judge, I would leave it to the court's discretion.
All right, thank you. I have received an Attorney General's report in this particular case, and they indicated that they believe that you're eligible. I just needed to find out whether or not your post-conviction circumstances warranted setting aside the conviction. It's been very nice to talk to you, for you to tell me about what you've been up to. I appreciate the fact that you've been working really hard. I appreciate the fact specifically that you've been volunteering in the community and trying to make the community better. Being able to give people a second opportunity is one of the privileges I have of being in this position, and it's my honor to give you that second opportunity, ma'am. Congratulations. I'm going to sign this order so that you can have this off your record.
Thank you so much, Judge Washington. I really appreciate that.
You will take care
Thank
of
you,
your.
Your Honor.
I'm signing the order.
Thank you.
State of Michigan versus Gerald Johnson, 24S00053.
Give me what's for the people.
Ryan Niskar requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Matthew Mansour, Your Honor.
Permission is granted.
Thank you, Your Honor. Mr. Johnson, can you please unmute and state your name for the record, please?
Gerald Johnson.
Thank you, Mr. Johnson. So I'm glad to see that Mr. Johnson has provided proof of his 12-step meetings. It looks like the probation agent is willing to work with you, Mr. Johnson, withdraw the violation at this time. And you still need to do that 30 days of community service, though.
Yes.
I'm sorry, what did you say, Mr. Johnson?
I say yes. I am working on that.
Okay, great. Anything else you want to say, Mr. Niskar?
Nothing further, Your Honor.
Thank you, Mr. Niskar. Ms. Woods, anything from you?
Nothing from the people, Judge.
So we're going to set this for a review in 90 days with the agent, as long as you provide them with community service, then I think everything will be fine. If not, then you'll be back in front of me again, Mr. Johnson. So I'm sure you're tired of seeing me. So you're going to see the agent next time in 90 days, okay?
Oh, okay. I got one question.
Yes.
Do I still got to do the testing?
That's a good question. Mr. Pappenhagen, what are you recommending regarding his testing? If you're present, good morning.
Good morning, Your Honor. I'm present. Just give me one moment to look at his current testing.
I mean, do you have a different like site location or?
My apologies, Your Honor. My system is currently not working.
So where do you plan to have it? We don't have a site, so.
Well, I can tell you that, sir, you had a positive alcohol test as late as February 4th. So I'm not willing to take him off just yet.
That
Uh,
that was a false positive though.
was it a false positive?
All of them was false positive. I had several of them that were that I contested, and they were all false positive. And I had been testing since April 3rd of 24.
Ms. Johnson, is your system working to show us what his last few test results are?
Your Honor, my system's working again.
Okay, thank you.
He did test positive for ETT on 2/4, but the results did come back as a false positive.
Okay. And that was
So
the
I'm
last,
taking-
okay. Then testing will be removed.
Thank you.
Then you'll see July 21st, 2025 at 9 a.m. with Agent Poppenhagen, okay?
Okay.
All right. Congratulations, sir. Keep up the work so you can get discharged and not have to be here anymore. All right.
Thank you so much.
You're welcome. Take care, Mr. Johnson.
Bye bye.
The court will call the case of the state of Michigan versus Daquan Delane, 23S00369.
What's for the people?
Mr. Delane, are you present, sir?
Oh, yes, I am. Sorry.
That's okay. Can you turn on your camera for me?
Yes, ma'am. Yes, ma'am. I was in the gym last night, so I'm sorry.
All right. So, Mr. Delane, you were arraigned before the magistrate on April 7th, and you got a GPS tether in a hot zone at the time.
Yes, ma'am.
And your attorney should have received notice of this, but your attorney is not here. Attorney
Yeah, I
Sa-
tried texting her. I tried texting her. She ain't answering. She reply back to my text message.
Yeah, we tried calling her and it's going straight to voicemail, so we aren't able to reach her today either. So I think we're gonna have to give you another court date, okay?
Okay, that's why I see Judge Carl Burton on June 4th for final trial.
Okay, on who? June 4th.
Judge Carl Burton on 1482 District.
Oh, okay. Carl Barr.
Yeah, Burt. Yeah, I know. Yeah, on
DA
June 4th.
Barr. But you're scheduled for a April 25th. No?
That's 2024 now.
Oh, wrong. Okay. Let me see. What are we scheduled for? So let me see. I know. I'm trying to figure out what happened though. Okay. You failed because we set it for another pretrial. We had been here, then we set it for a pretrial and a bond violation. All right, so I'm gonna put, and the bond violation is the new case in front of Judge Barr. Is that correct?
Yes, ma'am. I've seen him. Next time I seen him was on June 4th.
I see. All right. I think though, we need to figure out what's gonna happen with this case. So I'm gonna put this over to see if your attorney's gonna show up on May 12th.
Okay, 9
Okay.
o'clock at the same time.
Yep, May 12th at 9 o'clock. Bond is continued, okay?
Yes, ma'am.
All right, we'll see you May 12th at 9.
All right, have a good morning.
You too, sir.
Okay.
Bye-bye.
Well.
All right, we're gonna do failure to appears next. The court will call the matters of Lawrence Buckner, 23S00102, as well as 103.
Tiffany Woods for the people.
Assistant Public Defender Davi Lebo for Mr. Buckner. Your Honor, I did speak to Mr. Buckner on Friday. He was in custody at the Washington County Jail. I'm not aware if that's changed.
Good morning, Mayor. Please honor before Kareem Johnson on behalf of Mr. Buckner. Your Honor, likewise, I spoke with a family member, Mr. Buckner, on Sunday. He was in jail.
Mhm. Do you show him still in, or you working on that? They didn't get it wrong.
No, I know.
Did anyone check XJL to see if he's in?
I'm checking right now, Your Honor. Your Honor, he does still show in X jail. It looks like this case is missing from the X jail record.
Okay.
Your Honor, we do have exams scheduled for tomorrow in front of this court. If the court
Yeah.
wants to.
No, we're not gonna put them on for the same day because it's actually different jurisdictions. Seems weird, but it is different jurisdictions. I'll put it over for next week. Are you available on the 28th, Mr. Johnson?
Yes, I am, Your Honor.
Okay. Pretrial adjourned to April 28th, 2025 at 9:00 a.m.
Thank you, Your Honor.
You're welcome. Bond is continued. You say he's not in?
Are we not doing this kind of settlement? The 25th of April in Mr. Lebo's matter? Because he's currently on the front settlement on the 25th.
Wait.
I'm sorry. Yeah. Mhm.
What are you talking about? Okay. 1 second, because I just put them on for pre-trials on my docket. I don't know what you're talking about. It's got canceled. They did not.
No, they're still showing the record. So I mean, if you want me to take them off, I can.
Mr. Lebo,
Yes, Your Honor.
your matter is scheduled for a final settlement conference on Friday.
Yes.
Okay, we're gonna continue that.
Thank you, Your Honor.
Okay.
Judge, I thought both matters were set for a final settlement conference.
Are they? Okay, 1 second.
The 102 and
All right, we'll need to call Mr. Johnson to let him know that they both need to continue for the April 25th. I think he was saying tomorrow, but maybe he meant April 25th. Because I do have Mr. Buckner tomorrow on different matters. So we're gonna continue them on to the April 25th. Thank you, at 9:30 a.m.
I'm going to see who's else got a feed going, and we'll switch over while she goes through her failure to appears.
Court will call the matters of the state of Michigan versus Ron Webb, 25S 00146.
What's for the people?
You satisfied? All right, court satisfied as well. Factual basis here for the plea. Court rule has been complied with, and I will accept this plea, finding that it is freely, understandably, voluntarily, actively, and knowingly. All right, I'm gonna get a pre-sentence report. And he's in custody, so could I get one fairly quickly, Karen? Might have to call probation and see when they can interview him. And then give me that date. Right, do it on the same day. The what? Well, can they do it any sooner? You need to calm down there and ask. You gotta ask probation if they can get it done.
Miss Sheila courtroom a little slow. Let's see what else is out there.
Question cross-examine those witnesses against you. The right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have its silence used against you, and the right to testify if you chose to testify. Ms. Knopf, do you understand those rights?
Yes, Your Honor.
And once again, do you understand that if you enter a plea of no contest and I accept that plea, you will be waiving those rights?
Yes.
Additionally, if your plea is accepted, you will be given up the right to you'd be given up the right to file a claim of right to appeal, which is only allowed after a conviction is trial. Any appeal would be done by filing an application for leave to appeal. Furthermore, by pleading guilty, you may be given up the right to appeal issues that would otherwise only be appealable if you're convicted as a sentence. Convicted at a trial. You'll also be given up the right to claim that the plea was a result of any promises, threats, or inducements not told to me today on the record, or the plea was not of your own free choice. Ms. Knopf, other than the terms or conditions which we've talked about, have there been any other pressures, promises, threats, or inducements to force or compel you to plead guilty?
No.
Are you went to the plea of your own free choice?
Yes.
The court does have an advice of rights that appears to be signed by Ms. Knopf. I'll also add that to the file. Ms. Knopf, the next thing we need to talk about is sentencing. Now, Mr. Dobie and Mr. Hartel have told me about a pretrial agreement regarding sentencing. Go over that. The agreement is that when the guidelines are scored, which they estimate will be a 10 to 28.
Yes, sir.
Is that right, Mr. Dobie, 10 to 28?
10 to 28, yes.
Thank you. They have agreed that you'd be sentenced somewhere within that range. Now let's talk about that range. The guidelines are only a tool. They are not mandatory on the court. The guidelines can be estimated by attorneys who know what they're doing, and they can go look at prior PSI or pre-sentence investigation reports and prior convictions and look at your history and do a really good job making an estimate. The key here that I want to highlight for you is that it is an estimate. But regardless, the agreement is that you be sentenced between, the minimum end would be between 10, 28 months, with the maximum being up to 7.5 years for count 1 and up to 30 years for count 2. Or I'm sorry, what would be added count 4. Now let's talk about this agreement. I do not do Cobb's agreements. I only do what's called a Killebrew agreement. A Cobb agreement is one where I would join in right now and say, that's what my sentence is going to be. I don't do those yet because I don't know what the pre-sentence investigation report is going to tell me yet. But there is something else called a Killebrew agreement. A Killebrew agreement is one where you and the attorney reach an agreement. And that agreement, again, I've already said, is the minimum to be between 10 and 28 months. Now, the word Killebrew is just in the name of an appellate case in the state of Michigan, and it provides this. At the time of the sentencing, if I do not go along with the agreement, you would have the right to withdraw your plea and come back to this stage of proceedings. I don't know if I will. I don't know if I won't. I think these attorneys have probably done a really good job making estimates and working on this case. But I just need you to know that if I don't follow it, you have the right to withdraw the plea. Do you understand, Ms. Knopf?
Yes.
Did I miss anything, Mr. Hartel?
No,
I don't think so. Mr. Dobie, have I missed anything so far before I take the plea? I don't think I did.
no, Your Honor.
Great. All right, Ms. Knopf. Oh, I forgot to ask this. Ms. Knopf, back on November 17th of 2023, were you on probation or parole at that time?
No, sir.
Were you on bond pending any felony charges anywhere at that time?
No, sir.
You still wish to enter the pleas that we discussed earlier?
Yes.
And again, I highlight for you that I anticipate the plea to be no contest. As to count 1, concealing the death of an individual, how do you plead?
No contest.
As to added count 4, delivery of a narcotic or no cocaine in an amount less than 50 grams, how do you plead?
Contest.
And the next is, Ms. Knopf, do you admit that on or about February 17th of 2009, you were convicted of attempted larceny in a building in this courtroom?
Yes, Your Honor.
That satisfies the habitual offender second. Now, for the court to be able to take the plea, the court has in its hand People's Exhibit number 1. It is a preliminary examination transcript. The preliminary exam was done by the Honorable Audrey Van Alst in the 84th District Court back on Friday, October 4th of 2024. Mr. Dobie, are you asking the court to accept this for the basis of the no contest pleas?
Yes, Your Honor.
Mr. Hartel, do you have any objection to the court accepting this? People's Exhibit number 1 is hereby admitted. The court took the time prior to taking the bench this morning to review the transcript. This transcript included testimony from multiple people. It included testimony from a Sherry Johnson, Ethan Johnson, Connie Libby, and probably more particularly here, Detective Chris Peace Corps of the Wexford County Sheriff Department. The court also notes that there were references contained herein as to 3 exhibits. One included a screenshot from some phone messages. That was Exhibit 3. Exhibit 2 was a medical examination autopsy report. And number 1 was the death certificate, which are also hereby included in the taking of the plea. Mr. Hartel, do you believe there is a factual basis inside this exhibit?
I do, Your Honor.
Are you aware of any other promises, threats, inducements?
No.
Court's compliance to Court Rule 6.302.
Yes, Your Honor.
Mr. Dobie, do you agree with all 3 of those answers?
I do, Your Honor.
Is there anything else anyone thinks I need to cover before I make a or accept a finding? Mr. Hartel?
Not before finding, Your Honor.
Anything else, Mr. Dobie?
No, Your Honor. Thank you.
The court finds that the interest of justice did not require the defendant to recite a factual basis here today on the record based upon potential intoxication levels from controlled substances, but also from the potential civil liability that to which she could be exposed. The court also finds that the information contained in People's Exhibit number 1, including the 3 exhibits referenced therein, satisfy a factual basis for counts 1 and added count 4. There, and the court also finds that the defendant's plea today has been made freely, knowingly, and voluntarily. Therefore, the court finds that the defendant is convicted of count 1 and added count 4. And of course, did you need that PAC code again?
I have it. Thank you.
Counts 2 and 3 and the 4th habitual enhancement will be dismissed at the time of sentencing. And she's also found guilty as a habitual offender second, if I did not already announce that. Ms. Nulf, the case will now be set for sentencing. Sentencing will take place in approximately 4 to 5 weeks. Between now and then, you will receive a packet of information. A pre-sentence investigation report must be prepared. A report like this must be prepared anytime someone's convicted of a felony in a court in the state of Michigan. That report will include a description of the offense, description of the pretrial agreements, any statements, information you make or provide, as well as information provided by any victims in the case. Also include a recommendation as to the sentencing. Please compliance the recommendation. It will also include a complete history of your criminal history. It will also include a score in the Michigan sentencing guidelines. Please again keep in mind that the guidelines are an estimate. They are not mandatory. Anything else for the record, Mr. Hartel?
Yes, Your Honor. I do believe the people would be okay with waiving the 7 days notice if we were to address bond issues. I know there's been a finding, but if I could address that.
Any objection to me hearing a bond motion, Mr. Dobie?
Not at all. No.
Go ahead, sir.
Thank you, Your Honor. I'd ask the court to consider pending sentencing release to inpatient treatment. As the court did note, the finding today was in part my client was on drugs. She did have a bond violation when the court did give her bond in this situation, which we admit there was a finding. It was because of drugs. She has a lifelong drug addiction. She did go to the Sunrise Center in 2011 for 60 days and a detox center in 2013 for 7 days. However, she really realizes that without going into anything that would go beyond the purpose of the no contest, obviously, she has an issue with drugs. And she realizes there very well might be more incarceration at the end of this tunnel. However, she would like to approach whatever comes next with as much of the right skills as possible. And she knows that those are the places to find those skills. She has been to treatment centers before. She knows that she needs additional help. As the court does know, we have an office social worker, Mr. Brian Henniger, who would help with the middle steps if needed. I'd ask the court to give her that opportunity pending sentencing, and in theory, even allow her, if she does get that permission, to even be sentenced by Zoom if in the middle of treatment. Thank you.
Thank you. A very brief response, please, Mr. Doty.
Thank you, Your Honor. Though I do admit that her history shows that drug treatment would probably be beneficial. At this point, she has been found guilty of 2 serious crimes and is facing, even under the sentence agreement, possibly significant additional confinement. At this point, Your Honor, I do not believe that there is a right to bond, and I do not believe that a bond would be appropriate pending sentence with that hanging out there.
All right, thank you. The court revokes bond, remands the defendant to the custody of the Washington County Jail. This is a very serious charge. The court talks often about how drugs are not a victimless crime and they impact other people. And based upon the information considered inside the the preliminary exam transcript, the nature of the offenses here, no, this is a perfect example of drugs kill people. Therefore, the court denies the defendant any bond at this time. Of course, the court will next have the matter set for sentencing. Thank you. We're adjourned.
Thank you, Your
we have
Honor.
a series- Thank you very much, Mr. Joe. All right, we have a series of prelim, trial conferences. Anyone? Yep.
We have an attorney general on Zoom for 2 of the cases.
Well, let's take a look at those files then first. Which ones do I have an AG on?
But both of them.
Oh, I've got Miss House.
Both of them have defendants in our jail.
Okay.
Do you want me to call the jail and get the defendant?
Let's see, who's is Mr. Gallo? I don't.
He was on Zoom. He hung up.
Patrick, do we have any resolutions?
I don't even have an offer, Your Honor, since PCC, because this AG has.
Yeah. Okay. All right, let's go.
Do you want me to call the jail and have Mr.
Yeah.
Sutton?
Yeah. Why don't you go ahead and do that?
Okay.
All right, let's take it. Mr. Hartel, Miss Carey, and Mr. Harrison. We have any resolutions? All right.
Yeah, Cassandra, I wasn't sure exactly what they said she did, but it sounded like she maybe a user and she may have attacked somebody. And it also sounds like she's got a history. So but shout out to everybody kicking it with us today. There's nothing on. We're not starting anything new because we know Karen Reed is going to be starting tomorrow. So today we're just, peeking around in dockets around different states. This one here is from Pennsylvania. I think they do law. Interesting in Pennsylvania. I think that they are very law forward down there. So I thought this would have been an interesting thread for us or feed for us to watch.
All right, so the next 2 cases here are People versus Tony Allen Duke. These are file numbers 25-14040 and 1041FH. Court recognizes Miss Joanna Carey, the Washington County prosecutor, and Mr. Patrick Cherry, the defense attorney here in the courtroom. Joining us via Zoom any moment should be the defendant, Mr. Duke. We're here today in both of these 2 files for a pre-trial conference. They involve different dates.
They do, Your Honor.
All right. So I'm going to be, while we're still waiting, do we have any joinder issues? I mean, no,
I
I
think
mean,
they have to be
complete, like any of the same witnesses? No, okay.
No.
Like sometimes in this case, you'll have, say, one informant or something like that, and works both, but
The
that's
one
not.
was the arrest date following the other one.
Oh, okay, copy. All right. Now joining us via Zoom here from the Washington County Jail is Mr. Tony Allen Duke. Mr. Duke, can you see and hear us?
Yes, sir.
All right, so
Yes, Your
Mr.
Honor.
Duke, we're just here, thank you. We're just here today for initial pretrial conference. That's just the first opportunity where the court gets the file and can talk to counsel and the client and kind of tell me what's going on with the file. So the first thing here is, we have any discovery issues pending at all, Ms. Carey? Any drug tests or lab tests?
I think we are waiting on some testing.
Okay, all right. Anything else? Should I have to order transcripts here with the prelims?
No, Your Honor.
Okay. Any discovery issues and motion issues, Mr. Chair, you anticipate?
No, Your Honor.
All
I
right.
think there's a fair chance of resolution in these cases.
All right, good, good. All right, Mr. Duke, well, yes, sir, you get your finger up. Yes, sir. And by the way, for the record, it was an appropriate finger.
I was the pointing finger.
I know. Go ahead, sir. All right. What'd you need? What'd you need, Mr. Duke?
I know there's been stuff that was just taken off SIDNet that was taken out of context.
Yeah,
Hold on.
Your Honor, I received a kite from Mr. Duke over the weekend. I plan on meeting with him either later today or tomorrow to discuss the issues which he's concerned.
All right, Mr. Duke, you hear that? Mr. Terry knows about it. He's gonna come visit you. We don't want you making any comments here on the record today that could be inculpatory or prejudicial. All right, we don't have any issues here to cover today on the record. Sounds like everything is moving, and we'll have it, or we already know that it's set on the record for a final pretrial conference. All right, anything further, Ms. Carey?
No, thank you.
Anything, Mr. Cherry?
No, Your Honor.
Thank you, folks. We are adjourned.
Yeah.
We're all set, Mr. Duke. You're good. Good to go. Do we have anybody here in person we can deal with? What's your name, sir?
Ramsey.
Mr. Hartel? Court recognizes Mr. Nathan Carnes here on behalf of the people, and Mr. Robert Hartel here on behalf of the defendant, and Mr. Blau, the defendant, is now seated next to his counsel at table. Mr. Blau, as you just heard in the last file today, this is the first time where I get to find out what's going on in the case. If I need to get involved, then I do. If not, we just keep the case moving to the next court date. What do we got going on, Mr. Hartel? Any discoveries or motion issues?
No, Your Honor, I do believe we reached a resolution with the people, and I have it in advice and rights.
Well, okay.
Well, yeah, we should make sure the court's okay with the resolution because it is a proposed delay of sentence. So, okay.
Does he have, all right, so there is a proposed, what in the resolution is to do what? Why don't you go and tell me what the agreement is?
The proposed resolution would be to plead guilty as charged, but under a 12-month delay of sentence.
Do you have any prior convictions? Sure. The court's likely to grant the delay.
Okay. And
hold on, have you communicated this with the business? Is there a victim? Okay, never mind.
they do not wish to consult with me about resolutions for our form we sent out.
As long as you did that, and I don't feel like I'm shortchanging a victim.
Yep.
Okay.
Appreciate it, Your Honor.
All right. Then I'm likely to grant the delay. I can't grant it today, but I would likely in the future. If I don't, he has the right to withdraw his plea. Why don't you go ahead, so the agreement is he's gonna plead guilty as charged. The court will put him on a period of delay. And during that delay, if he's able to pay off
restitution of $2,829.68 to Cadillac Truck and Trailer. We would dismiss this.
Is that correct? Is that what you want to do? Yeah. Just raise your right hand. Do you swear or affirm the information testimony you're about to provide shall be the truth, whole truth, nothing but the truth? Yes, sir. Give me a lawyer hand. Mr. Blau, back on October 17th, 2024, were you on probation or parole at that time?
No, sir.
Were you on bond pending any felony charges at that time?
No, sir.
You are currently charged with a piece of paper called the felony information that I have here in front of me. You're charged with a single count. It is a passing of a non-sufficient funds check of $500 or more. That's a felony punishable by up to 2 years and or up to $2,000 or 3 times the amount that was written on the check. You understand?
Yes, sir.
I'm told today you're going to enter a plea of guilty to that. And if you do, the prosecutor agrees to have you sentenced in a certain way. Now, that agreement is that at the time of sentencing, you be placed on a period of probation under a delay of sentence. The court can only do that for up to 1 year. If you complete the terms and conditions of that probation, the agreement is that the charge would then be dismissed. Is that what you understood?
Yes, sir.
Now, that agreement is what we call a kilogram agreement, which means it's not binding until I get to court for sentencing. Let me explain that to you. I know I just said most likely I'm going to grant it, but here's why I don't agree to it now. Pre-sentence investigation report is going to be prepared. That report's going to go into your history. Once in a while, something comes up that you didn't tell your attorney about, not you, but other people. As long as everything's open and copacetic and they don't find out that you're actually a serial killer who's been wanted in 5 states, you're gonna be fine, okay? But that's really why I don't do it, because I don't know anything about you yet, right? I've never seen you. If I have, I apologize that I don't remember. But that's what it means. It's a kilogram agreement. As long as I go along with it, then you're done. If I don't go along with it, then you just withdraw your plea. Okay?
Yes, sir.
All right, now by entering a plea of guilty, oh, go ahead, Mr. Hartel.
If I may,
I enter a plea of guilty. If I accept that plea, Mr. Plow, you will not have any trial. Does that make sense?
Yes, sir.
You're gonna be waiving certain rights that you would otherwise have in trial. Make sense?
Yep.
Hold up this piece of paper that Mr. Hartel just gave me at the top. It says advice of rights. At the bottom, it appears to have your signature. Is that your signature?
Yep.
Did you read through those rights before signing?
Mhm.
Did you understand what you read?
Yes.
I think formally you understand that by pleading guilty, if I accept that plea, you will be waiving those rights.
Yes.
Additionally, waive the right to claim the plea was a result of any promises, threats, or inducements. That
All right, I promise I won't bounce us around too much, but I know that this courtroom is
promises, threats, or inducements
a
before
lot
us that can guide us
more.
to guilty that we have not yet discussed.
He has a very judge. I'm gonna say his
Has
name
anyone
wrong. I
made
want to call
any
him
final
Fletcher.
where there's this agreement?
He has
Has
a pretty
anyone
interesting
promised you
courtroom.
exactly what I'm going to do?
And he's live.
Hernandez, I'm looking back in zone. Okay.
It will say there, the state's
okay.
office on condition, correct.
Francisco Hernandez, coming up. Euler. Euler. You want to go look? We'll hold your place. Hey, who cares? Happy Monday.
To you as well. And
What's going on?
well, we're approaching a couple of different cases. I think one is the Andy Lara case, which is set for trial tomorrow.
Okay.
LARA. And but the state is anticipating dismissing that case. He's apparently done a plea in felony court.
Okay.
And he's going to take a TDC sentence. It looks like his report date is May the 7th.
Yes.
And so we're asking your permission to remove it from the trial docket for tomorrow.
I mean, if you know you're going to dismiss
Oh, we're
it,
going to dismiss it. It's just the only thing is.
what if he doesn't go do it though?
That's the thing. So I would ask to just move the date to May. That's the day after his report date. If he reports we're good, I'll done with that day. Sounds like he's already played. He's already played.
Oh, you're ready.
He's already played. It's not a complete issue. It's that he's played. He just needs to show up. So he's off the case.
Why keep it? If you know he's pled,
So,
you know,
Your Honor,
the
the thing is, I think there's concerning things that show up or not. I think Melanie just wants us to make sure. I know there's a bail jumping that can be filed. I'd prefer there.
Where's Klein here?
Well, no, he wasn't required to be here today.
But because would like you to impart to him that if he fails to show,
Well, there'd be a warrant.
well, no. But the entire range of punishment is at stake. So what's he looking at? Is it a second degree? No, do you know what's the last name?
Lara. What was the?
Is it a second degree or third degree?
It is a, let me go pull it. And it's an MAJ, Your Honor, so it's not actually a.
Oh, then that's even worse.
Right.
Let him know if he doesn't show, I could get the full range of punishment, you know? Yeah, I'm okay with doing which one.
Okay.
Yeah.
And the next issue we've got is the Brandon Lane jail case, Judge, and that's on your docket this morning. And that gentleman has several theft cases that are pending. You will recall that this is the gentleman we looked at doing a TRAS. TRAS came back with having issues about competency, did a competency evaluation, came back competent, but I don't see how.
So get a second opinion.
Well, and I think what we need to do at this point is just the age of the case, and that's what we're working on and getting accomplished. But is getting a date in the future just locked in now to have maybe a competency trial. And we'd like to get that in, I think we could meet our burden of, well, I think we could meet our.
You ever done one of those? Me neither.
Brad, I've never done a competency trial, but I can reach out to Brad.
Interesting.
What we need to do, what the procedure is, because I'm assuming there will be.
Do you want to just set it maybe like a week? You can look into it. You okay with that?
Was it set for a week to be like a.
Still evaluate, yes.
Just so I can reach out to Brad and be like, look, I've never done one of these. I'm not an expert now.
Well, and Brad may have some creative solutions that get us to a fair result, because he's been in custody for over 60 days.
If you don't think he's competent?
No.
And how on earth can, I mean, I don't understand how.
Well, so we had an agreement before that put him on mental health PTI. And
I don't understand how a clinical, a licensed, I guess is it, can disagree with you on this.
Well,
I guess reasonable lines different.
If you read that,
I just
report, I think even within that report, it says things like, well, he's maybe incompetent in hearing delusions and stuff at times, but he can still help his lawyer, and that's just not the case. And so, I mean, even the competency report finds that he's having delusions, and that was what he experienced when he did the TRAS. And so,
I'm willing to give you money if you want to go hire someone to have him reevaluate. Yes.
well, and that may be what we need to do.
You know?
But I just don't want him, I mean, the problem is he's been in custody for 60 days now, and picked up a new case while on the PTI, the exact same allegation. And so, but if you talk with Brad, you may find out something that doesn't prolong this. So
A week, see where you guys go.
yes.
Up with, and then I'm all ears.
Okay.
My other concern is this, is that at some point he's going to get out. Where is he going to when he gets out? Is he going to the street?
Well, and that's why
Do you know, does he have family members around? Does he have anyone around that's going to take him?
and that's why doing the mental health PTI was appropriate, because they have housing options over there, and it got him short-term housing. And that's why I went that way.
Stay.
Well, and they can help you when you're in that program, apply for longer-term housing. That was the best resources that I could help the gentleman get. And that's why we thought that was the most appropriate.
Every weekend with the.
Thank you, Judge.
Yeah, I was like.
Darla, are you ready?
No, guys.
Oh, is he not here?
No, he's there. I just wanted to look
Okay, you ready? We're supposed to do an arraignment. I don't know.
Oh, okay. Well, if you need me to step aside, just.
No.
I have Mr. Palacio today for a bond violation.
Come on, Mr. Palacio.
Do you need a copy of the bond violation, Judge? Okay.
Second bond violation. What am I supposed to do?
So his first one was because he picked up a new case. This one, I did speak with him. He is actively in IOP. I did show you those records at the last time that we were here that he got involved in IOP. He is getting drug and alcohol tested at his job too. He is a Marine recruiter. He did pick up some non-alcoholic beer. A lot of them still have alcohol in them. He was trying to still hang out. I get it. He realizes that that's obviously not going to work either at this point, that we're staying away from everything. But he did go get that.
I have to beg you not to violate your conditions of bond. Am I supposed to just be happy and let you go again? You know, either you have a problem or you just don't care about bond conditions.
Yes, Your Honor. I
just, whether you say yes, whether you say no, whether you say Your Honor, I already know, you know, I know my name. I don't. Well, the point is that you just don't get it. And what do I need to do to ensure that you don't get it?
So I have had several conversations with him, Judge. He is taking this seriously.
You had conversation beforehand.
I understand. He is actively involved in his IOP and has been continuously going to that. He is trying to make a change. He thought that he was doing something better for himself at that point. Obviously, that didn't work out. Right after do you remember the date? It was in March, right?
Yes.
Let's see.
I have like 2 weeks left.
So let's see.
Okay, so let's do this.
He had an initial appointment February 12th, but he did go into custody at that point. So then he had to reschedule it. So the beginning of March, he got involved.
Sending in for a drug and alcohol test. now.
Absolutely.
I'm sending you for a test now and you're to come right back. If you fail to test, you can fail to come back. I will revoke the bond. Do you understand?
Yes, sir.
Okay, take a seat for me.
Okay,
And then
let's judge.
just leave me your cell phone and then I'll get a hold of you.
Okay, do you want it now?
Don't speak it out loud.
Okay.
Yeah.
Wow, he about to test him and oh my gosh.
Michael
Stop
Pam.
playing.
You ready?
I'm Mr. Antonio Carrillo.
Leo?
Yes, Your Honor.
Hey, Stefan. Carrillo, come on up.
Good morning, sir. Sir, you were charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on each of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. On April 10th, 2025, officers were dispatched to a motor vehicle crash in Harris County, Texas. An officer already on the scene advised the officer responding that the defendant stated that he had a firearm inside of the vehicle that belonged to him. The officer identified the defendant by his Texas driver's license. The officer observed the defendant to have slurred speech and watery, glassy eyes. The officer observed an odor of alcoholic beverage emitting from the defendant's breath. The defendant consented to perform standard field sobriety tests. The HGN was a 4 out of 6. The walk and turn was a 3 out of 8. The one leg stand was a 2 out of 4. And the officer located a handgun inside of the defendant's vehicle during an inventory search of the motor vehicle. The defendant refused to provide breath. A blood warrant was obtained and his blood was drawn.
Okay. Can you tell me when was the first DWI? Number 1, how many DWIs? Number 2, number 3, does he have a valid license, please?
The date of the first DWI, Your Honor?
Correct.
2023, Montgomery County.
Okay. What was it? Well, obviously, it's some time. Any other DWIs?
No, Your Honor, but if you find it pertinent, a reckless driving from 2019.
Was it pled down?
It's, yeah, convicted on a lesser charge.
So what was the
original?
Right.
Your Honor, I believe the original charge was a driving while intoxicated.
Your Honor, running his license now, they haven't given out cold access yet. It's eligible, Your Honor. Bullet.
You know what a third DWI is in Texas? A third DWI is a felony offense of the third degree where you're looking at 2 to 10 in the penitentiary. I don't know what is going on with you, Mr. Carrillo, but if I find that you're consuming at all, I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. On your other ankle, I'm going to put a GPS monitor on you so I know where you are at all times because I don't want you out in the middle of the night. And on your other ankle, you're going to get a scram so I know that you're not consuming. If you have a problem with drugs or alcohol, now is the time for you to take care of it, because if it becomes a problem while you're on bond, I will do it for you and you're not going to like the way that I take care of it. Do you understand?
Yes, sir.
Judge David is not playing. He is not playing. He said you can't drink it all.
You are not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you use, I will revoke both of your bonds, put you in jail, no more PR bonds. Do you understand?
Yes,
I
sir.
want you to understand one more thing, that I'm going to do everything in my power to protect my streets at all costs. Watch the news every single day. We have a DWI fatality in our town. It's unacceptable. Do
Yes,
you
sir.
understand?
Yes, sir.
I'm not taking away your privilege to drive, but if I find that you're consuming, it's not going to go well for you. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Pham, and he will tell you if and when you have to come back to court. For the time being, I don't want you out in the middle of the night. We can talk at a later date if things, okay?
Your Honor, with the court, is you're waiving the fees?
Absolutely.
Thank you.
All right. Good luck to you, sir.
Thank you.
Right this way. You'll sign it, you have to manage.
Claudia.
Oh, Mr. D,
ooh.
I didn't see you there. I'm sorry. Come on.
Thank you,
Next
Judge.
time, just come up. You don't have to wait.
Judge, I'm here on Mr. Chauncey Joseph, DVR.
Yeah. Is Mr. Joseph?
He's here. Joseph.
Count before reset.
Just tell me what's going on, Mr. Joseph.
They said I left, but I ain't been going nowhere. I really ain't got nothing to say.
Okay, so.
It's this, are you there?
We're waiting on,
Yes, bond violation after bond violation. I'm
the
just,
chief is still in the process on trying to get me that surveillance video, Judge. That specifically allegedly showed the defendant inside of the vehicle, which would constitute a burglary.
let's do this. Let me take a seat for me in the jury box. Will you get with him to see what's going on with it?
Yes, sir. Yes, sir, Your Honor.
Yes, Judge.
Ready?
Yes. And it is.
Hernandez.
Good morning, Mr. Hernandez. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 12, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash and made contact with the defendant, who admitted to drinking 2 to 3 beers. The law enforcement officer observed the defendant stumbling and leaning on his vehicle to keep his balance. The defendant stated he did not remember what color the light was when he rolled into the vehicle in front of him. The defendant refused to perform standard field sobriety tests, but consented to a breath test and blew a .211 and a .204.
Ready to be honest?
No, Your Honor. And not in this county. I'm gonna check and make sure.
Mr. Hernandez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
No car DWS, Your Honor.
Okay, does he have a valid license? You mind?
Blaze, can you check the license for me? Yes, sorry. That's all right.
Mr. Hernandez, you are not allowed to drive unless you have a valid license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive as well. And that is a condition of your bond. Do you understand? Darla, do you know if he has a license?
I have made ALR request, but I didn't verify yet. No charge.
Sir, I don't have there is no driver's license number in our system.
You know the driver's license number?
Do you have a driver's license?
Yes.
Okay.
I'll let you guys check to see, Darla. I just want to make sure that it's eligible to drive. Otherwise, I'm going to have him sign an affidavit for the not to drive. So if you don't mind.
I did find a driver's license number on this CIC section.
No.
Joseph, I see your motion. Is that all you got?
Yes, sir.
I'm signing it for you.
Thanks, sir.
Got it.
I can step back, Judge. We can verify that. And if he does need it, I can then.
Yeah, just let me know.
Signed and everything. Okay, thank you, Judge.
Absolutely, for sure. So for now, you will get with pre-chopper your bond conditions. Don't use. You understand? Okay. All right, thanks, Darla.
Sorry,
I got it.
Okay.
All right, okay. Great. So we'll have you sign a receipt. You'll get pre-trial and then you're free to go. Thanks, Darla.
Right this way.
Hey, Carson. How are you, man? It's been a while.
Are you doing okay?
Yeah, you know, Monday after a holiday.
Baskin, Judge.
Baskin. Oh, you mind bringing him up?
Yes, sir. Mr. Baskin.
Go ahead and sign.
Good morning, Mr. Baskin. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 13, 2025, in Harris County, Texas, law enforcement officers were dispatched to a stalled vehicle call and observed a vehicle in a lane of traffic with damage to the left side of the vehicle. The law enforcement officer observed the defendant in the driver's seat, asleep with the vehicle on and in park. The law enforcement officer then woke up the defendant and noticed a strong odor of alcoholic beverage and glossy eyes. The defendant admitted to drinking one alcoholic beverage. Standard field sobriety tests were conducted, 6 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The defendant refused breath and a blood warrant was obtained and executed.
Any prior DWIs?
We have one that was dismissed in 2020.
You look at every full NCIC. Does he have anywhere else?
Yeah, let me see. I'm not seeing any other DWIs here.
I see a prior obstruction. Was that reduced? A DWI reduction? What county was it in?
It was Harris.
Mr. Baskin, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond, not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. Do you understand? So I'm not asking for much.
Oh, yeah, Your Honor, regarding the obstruction, it was just conviction on the charge that was filed on him, just obstruction.
Any other DWIs anywhere else?
No, Your Honor, it's not the one other than the one that was dismissed in 2020.
Okay. Interlock or no interlock?
Judge, to be honest, I mean, he technically has no DWI criminal history. I did not represent him in 2020, but he did pretty well in the field sobriety test. He's claiming to have 1 drink. I know that, he was 1 of 8, 1 of 4.
So it was a car wreck. I was knocked out.
Listen, if I find that you're using anything, not only will I put you in jail, but I have a whole host of devices, gadgets that are so damn invasive on you, you're going to think you turned into a robot. Don't use. Do you understand? All right, I'm not going to put an interlock now, but like I said, if I find that you, and I don't care what it is, cakes, candies, foods, gums, energy drinks, non-alcoholic beer, don't use. NyQuil, I don't care. Do you understand?
The excuse if it's.
For me, excuses go this, and they go. All right, you've got a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. He will tell you if and when you have to come back to court. If he tells me he cannot get a hold of you, you pick up a new case, it's just not going to go well. Do you understand? Okay, I'll have you sign a receipt with Victoria. We'll have you get with pretrial for your bond conditions, and then you're free to go. Thanks, Chris.
Big question?
Hi, ready?
Yes, sir. Bianca Lopez, she is in custody. I believe she's for a bond review, bail review. I don't know if you wanted her out or not.
This is really weird. How come they didn't give her a bond?
I'm sorry.
Why didn't they give her a bond?
I believe she was taken in, she had a warrant for manufacturing and delivery. No, this case is new, but she had a state jail felony warrant for manufacturing.
Oh, I
delivery.
see. Okay, I'm sorry, I missed it. So that's why they didn't, I see now.
Right.
So she's got a delivery case upstairs that,
No,
that's at no bond now.
Council Felicia,
So what do you want?
Well, Your Honor, if we could just give her a PR bond, I understand that she's on a no bond upstairs. She stated to me that she was homeless at the time, having all kinds of issues. She does have a place to live now, gave me an address. She's living with her grandmother. She signed up for San Maria, signed up to go to Santa Maria and has treatment. It's inpatient treatment.
How?
I'm sorry.
How?
She said through someone, she gave me a name, the name Sylvia Cordova.
Don't say the name. You don't have to say the name, but I mean, it's not through the felony court.
I'm sorry?
Not through the felony courts.
No, this was just.
So let's do this. I will say yes. But first, let's see what happens in the felony court. If she gets out on bond, then, because the problem is I don't want to say yes now, and then something happens up there, she takes off, and then we just don't see her again.
I
So
understand, Your Honor.
I'm okay with it, but
Okay.
find out what happens in the felony case.
Okay.
If they give her a bond, if she's able to make bond in there, let me know, and then we'll.
Okay.
I want to, before we let her go, I just want to talk to her to say, hey, look,
Absolutely.
don't get lost. Just stay with us, and then
So she's set in felony court tomorrow. Do you want to
do later this week, whatever you want.
later this week? Okay.
Yeah.
All right. So thank you.
I'm gonna look at the chair to get a letter for the volunteer.
Thanks.
Thank you.
Here's competitions here for the water. You got it.
Yes. You're welcome.
Oh. Use that video.
Hernandez, Francisco. Well, let's see,
Darla.
But I don't know, is that how much you have?
Oh, you need me now? Okay.
Councilor Lisa.
Hey, good morning.
I'm a person on this way. Yeah.
Guzman is the last name?
DIACK.
Oh, I see. Okay. You ready?
Yes.
Okay. Mr. Dayak, come on up. Good morning, sir.
How are you doing, sir?
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Eduardo Martinez?
Thank you, Your Honor. On April 10, 2025, an officer was conducting a routine traffic enforcement in Harris County, Texas, when he observed the defendant's motor vehicle fail to maintain a single lane and strike the concrete barrier wall adjacent to the road. The officer observed the defendant driving greater than 10% over the posted speed limit. The officer observed this by pacing the vehicle for a quarter of a mile with a certified speedometer. A traffic stop was conducted. The defendant was identified by his Texas driver's license. The officer observed the defendant to have red bloodshot watery eyes and a strong odor of alcoholic beverage emitting from his breath and person. The standard field sobriety tests were conducted. It was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and the defendant consented to a breath test. The 15-minute observation period was abided by. The breath test came back to a 0.139 and a 0.139.
Any priority to be honest?
No, Your Honor.
License?
Can I get a license status check?
Mr. Dayak, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. If you don't have it, you're not allowed to drive, and that's also a condition. Do you understand?
Yes, sir.
Now, good job on having a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with her. She will tell you if and when you have to come back to court.
Yes, sir.
If she tells me she can't get a hold of you because you're ducking and dodging and you pick up a new case, I will revoke your bond. All right? We'll have you sign a reset with Victoria. You'll get with pre-top your bond petition, then you're free to go.
Yes, sir.
Thank you, Your Honor.
Antonio Carrillo?
It's eligible?
Yes, sir.
Okay, great. Okay.
This is for me.
Yeah, we ran for free trial.
I'm working on the.
Yeah.
Mr. Gavin, go ahead and sign for your reset. So it's a very special days and then very shelf friendly and. Okay, go ahead and have a seat in the jury box. Yeah. Oh, yeah.
Absolutely.
Yeah, just.
The Villasana can now drive. Yeah. There's still no alcohol, no drugs. All conditions remain the same. The only thing is he's allowed to drive. Right? Okay. Yes, ma'am.
When you set this on the DRO, you said it 1,000, right?
Okay.
Yeah.
Yeah.
Council for reset. Yeah. Yeah, see, my vote this morning wasn't yet.
Hi, Ray. Ray?
Seeing where we're at for tomorrow. I think we're number one tomorrow.
You are number one.
I am number one.
You are number one.
Awesome. Good to hear.
State, great state of Texas. What's the word, Thunderbird?
Yeah, I mean, this is Thomas, right?
Yeah, Thomas.
Yeah, up to John will try and come for your today, so he's tomorrow.
Wait, who?
John Deaconport.
Okay, got it.
Talk to him, so he's ready, full house ready. Yeah.
I don't even, is it DWI?
DWI, immigration hold.
Oh, I see. Got it. Do you,
Is it a second? It is a second.
Chart and.
That's right. And the 0.15, yeah.
doesn't want to take anything?
Really can't. Immigration purposes. I'll go see him this afternoon if he changes his mind, but it's kind of one of those things where, we kind of have nothing to lose by going to trial. So, I mean, I think it's a pretty straightforward case. It's just a matter of,
I just volunteer that dude, because I've never been here to trial. How do you?
So what we do is we do voir dire Tuesdays, and then we start testimony the next day. So
we do it in the morning or afternoon?
No. Oh, morning. Everything's always morning.
Okay.
No, I don't. I do nothing.
I'm supposed to be in Brazos County tomorrow morning. That's why I'm asking. And I've been emailing them.
Process.
I know, I've been emailing them, telling them I can't make it, but they haven't responded. So, yeah. I'll be here. I
Okay.
just.
Well, if you need a
don't know what's gonna
protective
happen.
order, I can give you a protective order. You know,
I might, but I'm
um,
not there yet. If I need something, I'll just email you.
panel by noon, like right at noon. Hopefully we can get the panel quick, 9:30-ish. And then we can get in and out. If you guys don't go long, then we can be done in an hour and a half before that. So you could potentially be out of here, hopefully like 11:30. I don't know.
But there's 8:30 up there, so. Yeah, but there's no way I would make it up there and back in time. There's no way.
They don't have Zoom.
So they do if it's an agreed, so it's just on an expunction.
Oh, it's an expunction.
Yeah, I know. They can do, they said you can do Zoom if you haven't agreed, and the state hasn't answered any of my emails, so it should be agreed because it's been dismissed for ever.
So yeah, just let me see. I'll order the panel at noon and then we'll see where we are. Hopefully we can get it as quick as possible. Yeah.
And if he changes his mind, I guess sorry? I'll get him. The PD's office has that thing on the 7th floor where we can get him. I just need to know what size. He's my size, so I can kind of guess what size he needs, but I'm gonna go see him just to make sure everything's on the up and up and go from there. Cool. See you in the morning.
All right.
Judge
Hey.
Hi, good morning. How are you, Judge?
What's going on?
I have Diaz, D-I-E-Z.
Jail or on bond?
He's an ICE custody judge, so
Okay.
he's in jail. The state and I have been speaking. They're going to eval the case. I spoke with his immigration attorney. He does have a removal order, but they have appealed it. So they're just waiting to see what
I
happens
remember that
with
you were
the
talking about
appeal.
this.
Yes.
Do you know where we are with, sir, pull your pants up. Hey. Pull your pants up, man. I don't want to look at your book, huh?
So I did ask if there was any next hearing date for immigration court. There is no hearing date. So he already had the hearing regarding the removal order. And the judge gave the removal order, so they have filed a brief. So they're just waiting for a response to that. So there's no actual hearing set. They're just waiting to see what happens with that pending appeal. And in the interim, the state is going to be evaluating. It's a DWI first, no
The
priors.
thing is, though, is I can't show them preferential treatment in the way where I just keep giving you recess to figure out what's going to happen. And the case ends up getting 300, 400 days. I can't. So we have to do something at some point. So how old is it now? How old is the case now?
Let me see, Judge. My
Mine?
laptop actually just died on me. How
Is it on
old the
docket today?
case? Yes, it is, Judge. We rolled it from last week. Yes.
Hey, follow us. Just do this real quick. Let me do this. Come on up, guys. Behind the straw.
Good morning, Judge.
This is Mr. Gonzalez.
Yes, sir.
Good morning, sir. How are
So
you?
you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have already done. You need to understand that this is a lifetime thing that you're doing today, where this will end up as a conviction on your record. It's going to be there for the rest of your life. You can never take it off. But this is also an enhanceable offense, meaning if you continue to pick up these types of cases, at some point, they'll hit you with a felony offense, and then you're looking at years instead of days. You understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this offense, that's it. Let me see it. It's all this. Yeah, so your next one could be potentially a felony offense if you pick another one up.
Sure.
This makes 2. Do you understand? You take a case of beer. You understand? All right. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement, sentence you to it. Good luck to you, sir.
Thank you.
Thank you.
You get
Morning, Judge.
How are you?
Well, Mr. Jurisich and I had Mr. Greathouse, on Friday, I think we approached, we were trying to get his application to transfer to Dallas sorted, and should be good. He's pled to, Board of Third on FSRA with DWI conditions.
Okay.
We're asking the court to grant, to allow a time certain.
On the misdemeanor, so it's got the deferred conditions up there and a conviction on the DWI.
I'm okay with it.
Okay.
Yeah,
And we're gonna, we'll get it done today.
You don't have to worry about me for the transfer though, right?
No. Because
We're just, I mean, the transfer's over there.
yeah, the driver's just letting me know what we're doing.
Got it. Okay.
Thank you.
Yeah, for sure.
Okay, Judge, we have one that's set for arraignment with somebody open one, so it's going, do you want to do the arraignment?
Yeah. Hey, so Deputy Miranda, you know that we have to call for a panel before noon, right? Let me get you the cause number. Blaze,
Go ahead, Judge.
was that what? What's the cause number for tomorrow's trial? Never mind.
Well, what's the last name? Because we have the things in the.
It's Gomez, and I can pull the calls on there. I have it on there here. It's 253 2700. So.
Everybody show our girl Cheese some love.
And then, hey, I'm ready when you are to do that arrangement.
Okay, Echegom's gonna bring them out.
Better reductions in non-management expense. If you have big issues, you
So I'm gonna give it a reset and we'll start the agreement.
That's a very small.
Yeah.
Sure. We used to put it right in. If you don't have a green rec, it's issue states rec, I think it's here for. Okay, and then with the description, because they've already. I just thought we were trying to.
See them in processing so that
May we approach Ron?
Yeah.
You know, Mr. Cummings, Jeremiah Cummings, deadly conduct case. One, there was a question about PC, I believe.
So I've been trying to go Westlaw piece with busy here. I haven't had time to actually go.
I know, it's just.
Could I ask the court if that's the court dictates, we withhold them about all finding PC it's like a week and just. If I can do some research, if they're going to see how it's missing. But
I don't have a problem with that as long as he doesn't have to come back for the PC.
Well, I mean, if he's got, well, I'm gonna order him not to have be in possession of weapons. And then who's the complaining witness in this case?
it's Danny. It's
They live together, but I mean, they live together, and I think the original bond conditions were no harassing or
so.
harassing her.
Here's what we can do. Let me try to get on the horn for right now.
Okay,
Maybe I can do it quick, just Westlaw.
I'm gonna give you, if you want a couple days, I'll give you a couple days. My only,
but he's allowed to go back to the residence, right, Your Honor?
well, there's my issue, because what I want to know is, does she want him back? I don't know. Because whenever there's a complaining witness in the case, I always want to do what the complaining witness wants, and I don't know in this case. Now, that's why I.
Have they tried to call it them?
Well, we've been, I mean, we only have two. And we're like, remember, we had no court on Monday, so we're doing Monday's arraignments, we're doing today's arraignments, and then and on top of that, it's a holiday weekend, right? So just everything.
Because I think,
So-
double check with him, but I think he was able to go back, and I think he has been back since then.
I don't know. I don't know what the conditions, I think the match put conditions on, let's do this. Do you
Yeah, I think
mind
but the
stepping out?
magistrates just say no harassing or,
I'm just gonna step out to try to reach the complaining witness.
okay,
Step out. Okay.
okay.
That's all the way with the house covered.
This is a PC. Hey, who's this?
Delgado.
Okay.
Just to skip it on. Page 11.
Yeah, they didn't tell him that he couldn't.
Okay, I'll take a look. Sorry, let me just do this real quick. So,
Thank you.
yeah, hold on, PC, Delgado.
Oh.
You are Dean Delgado.
Yes, sir.
We have you in custody now, Mr. Delgado, because, all right. With us, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You also stand charged with aggravated assault with a family member. And in that case, there is a warrant and you're basically bond denied. You're being held at no bond on that case.
I'm already on bond for that, sir.
If you were, that bond has been revoked and it's now at no bond. That's why we have you in custody now. So what'll happen is we'll do PC today. We will take you in and then pending, you'll probably hit felony court tomorrow. And then you figure out what's going on with that. So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On April 11th, 2025, officers were dispatched to an officer assist call in Harris County, Texas. Prior to arrival of backup units, officers observed a motor vehicle driving backwards down the shoulder lane on Sam Houston Parkway with other vehicles on the roadway.
Driving backwards on the shoulder?
Yes, sir. With other vehicles on the roadway. Officers learned the following information from the investigating officers. Officers made contact with the defendant, who was the sole occupant of the motor vehicle. He was ID'd by his Texas driver's license. Officers observed the odor of alcohol emanating from the defendant's breath. Defendant initially stated he was not drinking, then stated that he was. Officers observed open beer containers in the front and back areas of the motor vehicle. Officers observed at the scene, officers that showed up as a backup unit also observed the odor of alcohol emanating from the defendant's breath and person, as well as slurred speech, watery bloodshot eyes, and swaying and staggering while standing. SSFTs were conducted, 6 of 6 HGN, 7 of 8 walk and turn. Defendant was unable to follow instructions on the one-leg stand. Defendant refused breath. Blood work was obtained and blood was drawn.
Mr. Delgado, I'm going to find the cause to go forward with the case. I am now taking away your privilege to drive and you are not allowed to drive. Do you understand me? You will be signing an affidavit with me today promising that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and $500 fine every time you drive. Not only that, I'm now placing a restriction on your license that you are not allowed to drive any vehicle that is not equipped with an ignition interlock on it. I'm sending this notice to DPS so that every single officer in the state knows if you're in a car driving and it doesn't have an interlock, you will be arrested. Do you understand?
Understand.
Not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke this bond. No more PR bonds. Do you understand?
Yes, sir. May I say something, please?
So I'm going to appoint you a lawyer today. You can speak to the lawyer, and if there's something that they need to get to me, we can, but I have a DA here and I don't want you to say something that could hurt your.
That's fine. I'll just like to put something on record, sir.
Don't. Now's not the time. Let me first give you a lawyer, tell the lawyer, give me 10 minutes.
I wasn't reversing. I was putting in.
Stop. Just don't. Now's not the time to fight your case. So what we'll do is I'm going to have you come up here, swear to us that you're not going to drive. Victoria, do you mind reaching out to the Mac so we can point Mr. Delgado a lawyer?
I just did, it's Sean.
Okay, got it. I'm gonna have you sign this here and then we'll put you in back and then I'll have Mr. Thatcher come talk to you here momentarily. Okay?
I wasn't reversing at all.
So do me a favor, give me sign conditions before he goes down. Please. Ready?
Yes, good morning, Your Honor. I'm here on two cases that I've been appointed this morning. The first is Miss Michelle McKnight.
Okay.
I think we have to address bond conditions.
Okay.
I think there was a MOA, this is the one we talked about.
Yes, and Your Honor, I do have to correct something I said there in the Wesley statement, just me going quickly. I mentioned to the court that on the terroristic threat and the interference with emergency assistance as well as the criminal mischief, that was the same complainant. It is not. They have the same last name. They both live at that same residence. So it is two different complainants that both were present at the same residence that all of these incidents occurred at. I'm not going to read into it. The terroristic threat complainant was a some sort of relative to the criminal mischief and interference complainants, either a mother or something along. It's not the same.
Okay. I mean, the fact remains she's still fighting with everybody at the house, right? And then
Right.
do we even know if they want her back?
There's no rip call done on it at all. I think,
like-
is there two MOAPs in place? Like, I'm confused because I was told that there's like a MOAP issue, but if there's two MOAPs that are being issued on two different complaining witnesses, or if there's just no returning to the
I haven't
house.
gotten that deep yet,
Okay,
so I don't know.
okay.
And
then also she has that on the terroristic threat, I believe. She has no.
Right, we need to, so there is a.
She's
bond-
GOB eligible though, I think, yeah.
I'm gonna give her one.
Okay, great. Thank
So-
you very much, Your Honor.
But I'm gonna order not to go back until we know that they.
That's fine. That's fine.
No.
She's staying at her dad's house, so for now.
And then,
So that's fine.
and then just, where is she? Is she here?
Yeah, she's. On the live stream, please, for her approach. Thank you.
Well, they're off the camera for right now. Let's see if we can hop back over to Judge Johnson's room. One second, y'all. I'm just trying to get us a good feed.
Was he previously giving you rides to and from work?
Yes.
How often would he do that?
Oh, no, we stated that is what we were doing. And I did get the bike.
Oh,
So
Oh.
he never gave.
Was there any reason why you would have been in the takeout area?
No. As, so when we're working in the cash register area, if you do work close to it, it would be for taking orders. And the team can take orders. But it would only be me in the area.
What was the nature of his employment, if you know?
He would do the job that I was in the cash register area, just giving people the receipts, making sure that order that they got is correct.
Speak with the chief. They are evaluating the case.
So the case is 70 days old?
Yes, that's at least based on what, so it's for Diaz, D-I-E-Z.
And your this is also the one that's in custody.
Yes,
He's not with us.
Not here, but he's in next.
yes, and they're waiting for the appeal.
No, it's 180 days.
I'm just going
From
based off of
September
what he
last year.
said. Yeah, he said 70. I don't know. I don't know, Judge.
Yeah, it's from September of last year. So we're working now 7 months. What, no, 8?
Yeah,
Oh, November,
I
December.
know that there are two other
months.
Diaz, D-I-A-Z, so I don't know if maybe that was a mix up, but
So let's do this. I'll give you one more setting, okay? 30-day setting. At that time, let's figure out what we're gonna do. But at that time,
Yeah, and that's totally fine. I promise I don't.
I'm gonna bench warrant him back because we need him to take care of this.
Okay, that's fine.
And Judge, we did speak, and again, they will be evaluating the case because the only real witness is a tow truck driver. If he's not like on board, I don't know how they'll prove operation.
Well, that's up to you guys.
So,
I don't, that's
Yeah.
not, I just want to make sure that we take care of this one way or the other and that, you know, we don't just languish. So Topic 13, we need a bench warrant this person back from ICE so we can take care of it. I guess, wait, hey, Blaze,
Yes, sir.
let's do this. Let's set it for a week. Eval it to see what you want to do with it. If you're still ready to go forward with it, then we'll bench warrant him. I don't want to bench warrant him now, and then you're gonna end up, you know, dismissing regardless, you know? Let's set it for a week, and then we'll come back and then, yeah, okay?
I'm sorry for that. I was going by the number that was given to me, so I did want to.
Thanks.
Thank you, Judge.
Hi.
Hi, First Judge.
Yes.
I'm approaching on Marquise Ally, A-L-L-Y.
Okay.
He was offered and accepted a mental health PTI. He's gone to the Harris Center. He's done everything he needs to do. We just still don't have the report yet from the Harris Center. And they typically, instead of doing the piecemeal, do it once a month. And it's been a while since he went.
You go.
Let me find the exact. He went. April 7th.
That's 3 weeks, 2 weeks ago.
Yes.
Yeah, that's not long.
Okay, just the case is super old, Judge, so you just didn't want it to fall through the crack.
So let's set it another 2 weeks.
Okay. Okay.
And if the report's not back then I guess I'll huff and puff and then I'll reach out to whoever I can.
Okay.
But we haven't given him, I mean, if you're telling me he went 2 weeks ago, that's just.
Well, and I spoke with him. I was able to confirm that he did go, so.
Yeah, I'm glad that you did.
Okay.
That gives me more assurance that we're just really waiting for the report.
Okay, thank you, Judge.
Doesn't he have to do something else though too?
No,
There's no follow-up?
typically no, but he's already receiving services through them.
Sworn that there was a follow-up
Yeah.
too. Oh, maybe not. Okay, so let's set it 2 weeks and,
Thank you.
yes, ma'am.
Hey, Jen.
Hi, Dion. What's up?
I'm good. How are you? Good. I'm Miss Bookman. We just got our blood. We're gonna do PTI mitigation and.
What's the last name? Bookman. Okay, what, it's, I mean, it's so young, whatever you want.
We're gonna do PTI mitigation tomorrow.
Okay, thanks, Dion. Yeah, hi, Martha.
How are you?
You know,
Monday,
yeah,
long weekend.
I got a case of the Mondays.
Exactly. So I'm approaching on Gonzalez, Diego Gonzalez. He finally got approved for PTI.
Is this the one we emailed this morning?
It was a hiccup, Your Honor, where I think we didn't realize the insurance, office set up the insurance.
Okay, so you got the approval.
We got the approval.
Great. We'll set you out 2 weeks to get it.
Perfect. Thank you, Judge.
Hey.
Okay, so you want to talk about this thing, nice. June 24. Yeah. Yeah. Yeah, I told him. Yeah. She's waiting for you to call me.
She's doing a call for sure.
Yeah, I'll go with him. I'm not scared.
Yes, sir, Your Honor. Judge, I believe that I have to approach you on Mr. Curtis Dakota. He was in another county at one time. I talked to the coordinator, and she says that she's going to treat it like an arraignment because he was out of county in another facility at the time that he was supposed to be in court here. So, but he's here today.
I'm bringing him up.
Yes, Mr. Dakota, step forward, please. Yes or no, sir? Or yes, Your Honor, no, Your Honor, to the judge.
Morning, Mr. Curtis.
Good morning, sir. How you doing?
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Officers were dispatched to a Holiday Inn in Harris County, Texas, in response to a disturbance. The caller reported that 2 white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed a Mitsubishi which matched the description given in the parking lot, headed toward the nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. Officer asked the defendant if he was involved in a physical disturbance, and the defendant stated yes, that him and another individual got into a physical fight, and that he got into his car to separate himself and calm down. The defendant stated he was headed toward a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 0 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were a .103 and a .113.
Judge, I'm going to say no probable cause here because.
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing. You know?
And probable cause doesn't exist. He's 0 for 6 on the walk and turn, 0 and 6 on the one-leg stand. There is no law in Texas that a person cannot drink. Just because he smelled alcohol does not mean the person is intoxicated.
Do we have anything that he's doing, you know? Tell me what led them to him?
Yes, sir. So what led to the investigation was a caller who reported the disturbance. The officer arrived and he observed a car which matched the description that the caller
That would be
gave.
like me calling and saying, hey, this guy did this over there. The cops, no. And theoretically, would be anyone could make a phone call, make an allegation, cops go boom and just stop, do whatever they want without, no probable cause.
Thank you, Judge.
Be careful, man. There's a lot of haters out there. Don't let them get you, you know? Life's too short. Sorry? All right, good luck.
Thank you. Gina Cody. The forest, they want to talk to the, that time is with the
Or the 19th?
Hey, okay. Tell me.
Yes, Your Honor. We spoke with the complaining witness. She stated that an argument did occur. She did state that the defendant has been in contact via phone and one time in person. Maybe she seemed reluctant to tell me as if she didn't want to get the defendant in trouble. And now she states that she has no problem and is okay with getting around the defendant. Yes, Your Honor.
Mr. Cummings, coming up. You, Blaze, you want to do a week?
That's fine, right?
Okay.
That works.
Okay, I'll waive it for
Okay.
that week.
Okay.
So Mr. Cummings, I'm not going to make a decision. I'm going to let both lawyers brief the case so we can get more of an understanding as far as law.
Yes, sir.
As applied to your case
Yes,
to
sir.
make a good determination whether there's enough probable cause to go forward.
Yes, sir.
In the interim, don't have any weapons. If I find that you are with a weapon, if I find that you become a danger, I will revoke your bond and put you in jail.
Yes, sir.
I'm not asking for much.
Yes,
You
sir.
know, there's a lot of relationships that are volatile relationships, meaning ones that you're constantly banging heads.
Yes,
This
sir.
is one of those. Be careful because you could be on the losing end of that. There's a
Yes, sir.
lot of vindictive people out in this life, you know?
Sir.
Put yourself with good people, none of that happens, you know?
Yes, sir. I understand.
I'm okay with you going back, but just don't have any threatening or harassing
Yes, sir.
contact with this person. It doesn't, I don't care what you think is threatening or harassing, it's what she perceived. So is this threatening and harassing? It is, and it can land you in jail.
Yes, sir.
Conduct alone can violate. You understand?
I understand.
Okay. I'm gonna have them create the bond conditions, we'll have you sign it, and then I'll have you'll be free to go. Just stay in touch with her and she'll tell you what happens next week. Okay?
Thank you, Your Honor.
Thank
Don't
you.
leave yet. We need you to sign conditions and then you can go. So no weapons, no threatening, right?
Your Honor, if he goes down, can he go down and put money in the meter and come back up?
Yeah, just make sure you come back to sign the conditions. If you don't, I will issue a warrant.
I'll be right there.
Okay, take your time.
Sorry, not 13, 14, 21, 22. He's getting on. All right, how's the 28th or the 30th?
Oh. You still have Piedra down back there, right? We gotta do PC on that kid. Yeah, you still got him? Okay, we need a translator and I need, is it Maria?
Yes.
She's, oh, there she is. Okay, yeah.
And he went down to put money in his meeting. Okay, very
Oh.
Yes, sir. Judge, I've spoken with the chief on Mr. Chauncey Joseph. The chief is willing to dismiss the burglar of a motor vehicle because they can't get the video that alleged to have shown one of the persons inside of the truck. And he's willing to give the person 9 months, Mr. Joseph, 9 months deferred on the unlawful carrying of weapon, provided that TRAS supports that.
TRAS done before plea. Before the plea, then I can get, we can get a lot of.
So you want to do that?
Yes, sir, he does.
So let's send for a TRAS now.
Yes, sir.
And then we'll, I guess, set it later this week to wrap it up. I mean, or how long you think?
Mental health issues.
No, sir, I don't think, ma'am. No, ma'am. About a week.
Okay, done.
Thank you, Judge.
For sure. Hey,
Yes.
that's okay.
I'm here for Nava. He is here for just a drug test today. He's now set for 2 drug tests a week. He's been doing it for like 2 weeks now, or 3 weeks, I think, the drug testing. I was wondering if it would be at all possible to do once a week, just because he's having a lot of trouble.
I'm okay with that, but it will be random though. So he
That's
doesn't know
fine.
when, I'm okay with it.
Okay, yeah, he's just having trouble like getting here. And so it's like an issue. Okay,
Tell him not to use, because
that's fine. So would it be once a week randomly? Okay, okay, thank you, Your Honor. I'm gonna wait for him to
the
come
problem
back
is,
so I can
the
tell him.
problem is this, is that they're gonna call him
Right,
to make it up here.
yeah. Yeah, it's just, right, and it's like, he has indicated to me that he like wants to resolve this all because he can't get down here, and I don't want that to be an impediment on the adjudication of his case, and so I'm trying to figure out how I can make this easier for him, but still abiding by the conditions the
I'm
court
willing
wants to
to
impose.
say, yes to you,
Okay.
but he's got to make it here.
Okay,
he
and they would
doesn't.
be random?
It'd be random. That, well, because then you can prepare for it.
Right,
It defeats the entire purpose, you know?
I get it, yeah, okay, thank you, Your Honor. I'll wait
Only
for.
other thing I can advise you is if he wants to, he can go to a Quest where he lives,
Mhm.
close to. I don't want Ponca City Labs. I want Quest because I know they're legitimate.
Okay,
He'll have to foot the bill because I can't pay for that.
okay,
If he
okay,
wants to do that, that's the only other alternative.
okay,
He's got to foot it though.
okay,
And it's got to be like a full panel so we know.
right. Okay, I'll talk to him. I'll talk to him. Okay, thank you, Your Honor.
Judge Dayton Johnson. Johnson, last name Johnson, first name Dayton.
How are you?
I'm doing well. How you doing?
It's Monday.
Yeah. It's been
What do you want to do?
Blade gave me a class, forfeit the weapon, a gun safety course and forfeit the weapon.
Okay, So it's at 190 days now. What kind of class?
Gun safety course.
A week?
Okay. That works.
Let him know if he doesn't have it done, you gotta be here. Okay.
Sure.
Jillian.
Morning, Judge.
Hey, good morning.
Morning. Mr. Waters should be there. He may be in the hallway. Ronald Waters.
Okay,
Last setting, you had reset him to go to his appointment to get a ID.
you get it?
No, he's got he said he had some paperwork from the DMV. He went and apparently he had copies of his birth certificate, copy of his social security. So they said that he would need to have something with his picture on it. They suggested that he get an offender ID card. So they gave him a new date of May 6th.
It really takes that long just to get an ID card, an entire.
I do believe that he went. I'm not sure what it is they want from him.
Well, they need proof that it's you, right?
Yeah.
Anyone can have a birth certificate. The problem is it doesn't have your picture on it. So usually at least 2 forms, and they tell you beforehand what you need.
Right.
I failed to let him know to check what they need before he goes.
Yeah, well, he said he had everything they need. The problem is that it was a copy of it. I'm guessing if he had the originals, he wouldn't need a picture of anything because you don't need a picture if you have the forms of ID that they asked for.
Yes.
Guys, do you mind grabbing Mr. Waters from outside, please?
I think I saw it at Move it ahead. Okay. Okay. All right.
Hey, Seaman, how are you? You want to talk to me real quick? You need me? No.
Just I'm waiting on Day. I have a fugitive on the docket. She agreed to waive, but I had somebody in the back translate for her, so I just wanted to make sure she understood before I had her sign it.
No, that's a good idea, right? Because this is.
Mhm.
Yes.
There's no Mr. Waters here, Jillian.
Yeah, so he checked in. He checked in this morning in court 5. He did not realize he had felony court, so I told him to go to felony court. I just got off the phone with felony court. They said they did not take him into custody for being late, which they threatened to last time, and that she did reset him just now, maybe 10 minutes ago. So the number he called me from was actually some random person in the courthouse who he doesn't know. So that's who just picked up the phone just now. So I guess maybe we just give him a few minutes.
Okay. Hey.
Sent off docket mandate for motion to withdraw. Matthew Leonard, you revoked his bond on 4/11. not coming to court. Haven't heard from Mr. Leonard. This was a DWI case, and he's having some issues with Scram.
Oh, yeah, for sure. Yeah, absolutely.
Thanks.
For sure. Hey, you withdrew. We got him. You want him?
Well, someone else was appointed, so.
How? Were you already on?
Because I guess because I put in with the Mac that I'm on. And so
It's still it's still the attorney record, so it wouldn't, it shouldn't, you know?
did someone else handle it while I was not?
No. You've been on the way.
I'll stay on it. I don't think, I mean, it's fine.
I don't care either. If you want to.
I don't care. I thought. Because
Hey, Victoria.
Oh, maybe because of the mental competency issue from the past. Yeah, that's what the PDO's taking it over. Maybe that's why. It's not well.
I guess that is one.
Why do you point someone else on July?
That was from Thursday last week.
Greg is on it. He's the attorney record.
I think Spanish. That's what it was. It was requesting of Spanish and he had an ice hole. But you know, when we give them to you and they're in another county, we don't know yet.
He speaks perfect English.
Speaks perfect English.
Really?
And I think he told me he's a citizen. Oh, he's from English, it's fine to me.
I spoke to him.
I had the people request because I remember.
So did you appoint someone else?
I sing legit.
It's not good. You're on.
Give me the case number. I have it because he's on tomorrow. I mean, I can be back. I'm here tomorrow if you want to do it.
What's your cost number?
255-6469. This is all.
No, that's the right one.
Does he have a nice home? I didn't think you. I'm here tomorrow. I'm swing by. I see him.
Would you think Cheryl? Oh. We talked about it.
Hey, Dave's here.
He doesn't.
Okay.
Thanks for dismissing all my cases, Bob.
Good to see you. It's been a while.
My last week with Amy, y'all are gonna be seeing a lot more of me very soon. So.
When's your last day?
The last day is Friday, but I'll be on Friday. So Nicole's gonna be covering for me on Friday, and then next week it's just, unless I'm out, it's gonna be.
You need a translator?
He said Paul.
I got married.
Is that what it is, the name?
Is that your client?
Yes, yes, and so I just wanted to make sure she understood. She said she would wait and go back to Wisconsin, but it was one of her fellow people.
I don't know. I think that we should get a translator, you know, because.
Yeah.
So she doesn't speak Spanish and she's only a Spanish speaker. And so we've got.
Right? Yeah, so.
We need to get a translator. I don't want it to come back somehow because she doesn't speak English, you don't speak Spanish. And she had a translator from one of the inmates translate, so.
Collective effort.
If you can give me like a couple of minutes, let me see.
I'll stand down.
We're gonna get a translator. I don't know where he's at. We're gonna get one for you though. I thought you said Spanish.
I speak a little bit Spanish, but I don't speak English. I understand everything.
You're speaking English now.
Sí, poquito, pero va a traer un driver. Pero va a sacar su cheque.
No, vamos a sacar una persona. ¿Tú hablas español?
Sí, sí, señor.
Ok, un segundo, vamos a sacar una persona que te puede ayudar.
Well, that explains the part of the fugitive packet that we received because they had issues with having a translator. I guess if Romanian is their primary language, that's probably why they have difficulty.
You say Romanian?
Yeah. Yeah, so that's our primary language. She may speak some Spanish and some English, but I think that's why the paperwork initially, when they said they didn't have a.
If you want a Romanian, that's gonna take at least a day, man.
So the lady, I think she speaks, I think Spanish is her second language. Romanian, Spanish, little English.
I guess let's do this. We'll see if, we'll get a Spanish translator. We'll see, we'll translate it, see if she's able to communicate back what was said.
Okay.
Yeah. Vic,
I'll stand down.
we need to translate it.
I already said for both Sony and Plaza for Maria, so I'm waiting.
Okay.
I wanted them to show it.
Judge, just to let you know on Lane, we reached an agreement on Lane as to one of the cases. And we're gonna move forward with a plea on that.
No, really?
Well, yes. And,
I know, but it's like,
well, and
He's at 55 days, you got 5 left, they had 180 or something like that.
and he had prior in custody for some of
I'm gonna
them.
see if a social worker can talk to me between now and then.
And we had a conversation officially to that I have, and we have the prior report, and so.
I mean, ultimately, he's in the driver's seat. I can't.
Right, and just, I mean, maybe we can, he does have a prior, it's in full felony theft eviction, so he gets another one. So
Yeah, right. Uh-huh. I believe you.
Just saying, I
I
mean.
believe you.
You know, I love that judge can find a, well, we have to, yes.
Just everything is in here, just humor. Anyways, if that's what you want to do, you're in the driver's seat, you know.
Well, I have my
It's up
own
to you.
feelings, but respect client's position and sound like it was a good conversation and understand what's going on this morning. So we'll move forward that way.
I mean, I trust you.
Thank you, Judge.
Yeah, apparently, I mean, I will swing by tomorrow, but apparently, yeah, the PD's office is on it. It's on spot.
Can I talk to you for a second? Instead of that. You want to just. Hold on. Okay. Stay.
Okay.
Yeah, that's.
I don't know, it shows that you. It shows that you were appointed and when you were hired, I don't know, so you were hired. Extremely forward. Let me read you. No, you are this. But I know that's what it is, you said you were appointed, I'm sorry, I'm sorry. You were. Yeah. Take off as a point. They're not gonna sign it.
I know.
Just the motion. I'll fix it to where.
Baby, I got your number, don't you want? All right, you ready? Please.
Well, that's all right.
Let me know if there's anything else.
Okay. Gracias.
All right, good morning, Mr. Greathouse. Looks like you have worked out an agreement where they're offering you time served on DWI. You need to understand that this is going to go on your record. It will be there for the rest of your life. Do you have a CDL? This is going to suspend the CDL. You know, and like we talked about earlier, when you have a CDL, you're held at a higher standard to everyone else in this world. Because of that, you drive bigger machines, more dangerous, heavier weight. So if you get into an accident, it's so much worse. So the other thing that you need to understand, you pick up another DWI, you can lose that CDL for life. A second DWI conviction is a lifetime suspension of that CDL. You understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. There's no turning back. You can never, it'll go on your record. It'll be there forever. Is this what you want to do?
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow the agreement. It's 3 days in jail. Credit for the 2 days that you've done. You know, the idea is that we all make mistakes, right? But the idea is that you don't continue to make mistakes that you endanger other people's lives. That's why we have greater sentences. That's why we have prisons. That's why we have jails, because some people just don't get it. Do you have to go to prison to learn? You know, it's a rhetorical question. It's not, but you don't have to answer. I'm just telling you, that's why we have enhanced punishments, why we do longer jail sentences, because some people just don't get it. I mean, really, if you want to get lit, great. Take an Uber, $40, $50 it could have cost you. One button. I hope that you use it in the future. I also have to suspend your license. I'm going to do it for 90 days. That is the minimum.
Thank you, Judge.
Just be careful, man. It's not hard, right? Just, you know, if you're going to go out and get lit, if you do it, just really. How do you think? Did you say guilty?
You did, Judge.
All right, I'm going to find you guilty. I'm going to follow the agreement. The other thing is this, the reason I'm telling you about the mistake is because your lawyer is asking me to waive the fee for you. Is this above a 0.15 or no? No, it's not. Let me see. Great. This is a $3,000 surcharge that you would normally be paying on top of this. All the other stuff that you're doing now. I'm going to waive it for you now.
Thank you, Judge.
But if you come back with another DWI, it is a $6,000 surcharge that tacks onto you. Do you understand?
Sir.
All right, good luck to you.
And Judge, I would just submit to the courtroom. He has taken this seriously. He's done a lot of things. I think he's made the start of a good recovery. So I just would submit.
That's great. But the problem is that time heals all wounds. It's fresh in you now. What's going to happen in 20 years? Are you still going to remember this in 20 years when you go out on a date and you're just, that's the rub. Are you going to remember this in 20 years? Are you going to remember this in 30 years when there's a death in the family, something that you can't overcome and you go out and you just get blitzed? You know, that's the true thing. That's what it's about, you know? Good luck. And for what it's worth, you're doing great. Just keep it on.
I'm gonna remember you. You're like that father that I never had. That was my brother. Every time I came in here.
And that's what we do, you know, like I've got 4 great kids at home and then I've got another 2,000 kids here. Some grow up and do great. Some kids, I got to sit there and freaking, you know,
Thank you so much.
just.
Thank you, Judge. Maybe excuse me.
Thanks.
It's a great idea. We got a collection.
Maria,
I'll take the first one.
you ready? Hey, we need,
Yes, I just told Miranda, bring them out.
Real quick on Mr. Waters, it obviously does not take this long to go from the 180th to court 5. I'm thinking he might have left. He was kind of in a panic when he realized he had felony court. Can we roll him to tomorrow? He did check in this morning.
okay. Well, SFBF tomorrow.
Thank you, Judge.
Yes, ma'am. Ready?
Yes, Judge.
Yeah, who was your guy again?
Judge, I got appointed to 2 in custody clients. One of them is Clemente Piedra Arana.
Baskin,
And the other gentleman, Judge, is Portillo Lopez.
Okay, I think we're doing this first. Give me a sec. If you don't mind, I have this waiver.
Oh, yes, Judge.
Sorry.
Yes, Judge.
You ready?
I'm ready, Judge.
You brought her up.
Ready?
Buenas tardes. Yo soy su intérprete. Por favor, conteste todo a voz alta. Ok, gracias.
Mahalchi Mahalchi?
Mahalchi.
Mihalake.
¿Cómo es?
Mihalake.
Mijalaki. Yes.
They gave a cause number.
It's 2560620.
Not found.
2560620.
Case not found.
I'm having the same issue with the other case, 2560601. On that one, the 02 was refused, but on the 01, I'm not even able to.
I mean, it's pulling up right here.
It's a deed
Don't,
issue.
don't.
Oh,
It's a deeds issue, so I'm gonna send a.
Can I see that thing? Thanks.
is that why there was a packet issue this morning, right? For the. Because that's why Amy was asking the packet, because it wouldn't upload into the.
Not sure what's going on. It's just these two cases.
Okay, I've noticed that for a couple of them on our emails. It's just.
Yeah, it's not on my diet. I don't know. All right, so Ms. Milhachi, you are wanted out of the state of Wisconsin for misappropriating, identifying information to obtain money.
Para obtener dinero.
You are familiar and they have explained this document to you. Am I right?
Yes.
And you understand that you want to waive extradition. Is that right?
Yes.
You understand that they have 14 days to come get you.
Ya para que vengan a buscar.
Specifically, Wisconsin has 14 days to come get you. And if they don't come get you within that time,
No vienen
Harris County will release the hold.
durante de Harris, entonces.
This is how you understand this?
¿Entiende? Sí.
Okay, so what we need,
So I just signed for 14 days, right?
correct, and we need you to sign, I'll put an X here, and we just need you to sign this document here, and then. Guys, can you help her out? She needs to sign. I want to make sure that Tony's. Okay, but you're more like him.
No está la X.
Aquí, gracias.
Ahí. Go ahead and discuss with me, Judge.
Yeah, back here so we can file it. Okay, all right. Good luck to you, man.
Thank you so much. Thank you. Thank you.
And then don't, we still need you. Then bring someone else. in. Hey, Victoria, Waters SFDF tomorrow.
St. John's.
Great.
I do have yes, the cases you just file, like.
That's cool.
There from one island. But it's like,
Does everyone go over
but like,
Yeah.
nothing has been.
both cases on page one, several Raymond relative here?
So 2501 on the top, and then on Miss Alvacieli, 5002
To mark up.
on the mischief. The terroristic threat, is that, when's that on?
It's set on 512 for THA.
I'd like to get a hold of them with pre-child to see, let her know that we're gonna put on the docket for a week. Cause I'm not gonna just,
Okay, so for the terrorist threat, you want to put it on the week.
yeah,
Put the law on today.
great, I'm revoking, yeah.
Okay. Oh, shoot.
Okay, ready?
Parece que aquí contamos de su intérprete. Por favor, contesten todo o calma.
So who is Piedra? That's this young lady. All right. Good morning, Mr. Piedra. You were charged with two cases. You were charged with driving while intoxicated. You were also charged with failure to stop and give information. On the DWI, you're facing up to a year in jail and or a $4,000 fine. On your failure to stop and give information, you're facing up to 180 days and or a $2,000 fine. You are currently being held at no bond. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
Thank you, Your Honor. Law enforcement officers observed the defendant driving over a median in the road. Law enforcement officers observed the complaining witness Kirkland and witness Taylor screaming at the defendant to stop his vehicle. The law enforcement officers removed the defendant from the vehicle and they observed the defendant to have strong odor of alcoholic beverage, swaying, and red glossy eyes. The complaining witness stated that the defendant struck her vehicle, that he got out, looked at his hood, but never exchanged information. The defendant then got back in the car and drove off. The damage was approximately $300. Standard field sobriety tests were conducted, a 6 out of 6 on the HGN, and the walk and turn and one leg stand were unable to be performed due to an old foot injury. The DIC was read and breath was collected.
A little bit slow, folks. She's translating.
Yes, Your Honor. Yes, Your Honor. The DIC was read and the breath was collected. The test results were a 0.244 and a 0.234.
You said that he took off from the accident, right?
Yes.
Did I miss that? How far did he go until they caught up with him? He has an open terroristic threat. Threat's open, right? Piedra, page 57.
Judge, it just says that the complaining witness and the witness followed the vehicle until he made a complete stop.
And then the cops arrive at that location.
Yes, Your Honor, and that's when they got out of the vehicle and began screaming to get the defendant out of their vehicle to pull over.
I think he has an open terroristic threat from 2001.
2020.
From 2021, he has an open
Yes,
terroristic
Judge.
threat. Am I
Yes,
right?
Judge.
Right? Am I right?
And he tells me that he was deported. And that's why he did not come back to court.
He's in jail and all those, Judge. I don't know why they keep showing.
Why is it show inactive then?
I'm not sure why.
But it is an open case.
No, well, he got picked up. He's gonna be picked up on. This is here. He got picked up on terroristic threats. 417.
So it is open.
Last Thursday, he got picked up on that warrant from 2023.
Okay. I find, Mr. Piedra, that you are a flight risk. I don't know that you got deported. All I know is that you have an open case from 2021. And the only reason that we have you now is because you picked up these two other cases. So I'm not going to give you a PR bond. I'm going to set you bonds on both of your cases, but I'm going to tell you now that you are not allowed to drive. I don't know if you're going to bond out, but if you do, you will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's a possible punishment of up to 180 days in jail and a $500 fine. Do you understand? You were ordered not to consume alcohol, illegal drugs, and I'm going to put a guardian interlock on you. If you get out, you must obtain a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol.
Okay.
No alcohol, no drugs, random testing, no driving. Guardian NOR. We have given you a lawyer, Mr. Piedra. It is your responsibility to stay in touch with her. If you do bond out, you must stay in touch with her. If you fail to do this again, and if you fail to come back to court, then I will make your bonds high. So I'm going to set both bonds at 5,003. And then the terroristic threat is right now set at 1501. I'll just leave it as is. And then I don't know if he's going to bond out or not, but if he does, then he will be required to comply with the bond conditions. I want you to understand, Mr. Piedra, that I'm going to do everything in my power to protect my community at all costs. I just don't want another death on the roads. That's all I'm asking. Okay. And then this gentleman is,
And this is Mr. Portillo Lopez. And he does have an immigration hold, Judge,
Mr. Portillo.
as well.
Is it under remote? Yeah, there it is. Okay, Mr. Lopez, you were charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. As part of your bond conditions, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you do not have a Texas driver license and liability insurance, then you are not allowed to drive as well. I guess will do whatever you want to do with Mr. Lopez. Right now, he's got the immigration detainer, so I don't know if he's going to be able to bond out. So I guess we'll just give you a week or two setting, and then just let us know what you would like to do.
Yes, Judge.
Okay.
I don't know if I don't think he's had probable cause, Judge. I don't see it.
He has.
Oh, yes, okay, Judge.
I'm showing that. Let me see.
All right.
Yeah, they found a problem.
Okay.
April 20th. So last night at 4:54 in the morning.
Okay.
Thanks.
So.
On page 10, Curtis, was it OPC? Are we expecting a nollie on that one? Also, April's in the waiting room.
Can you do me a favor? On Agbacieli, she picked up a criminal mischief.
How's that one spelled?
AGB, Agbacieli. She was due here for a new case today. Is the criminal mischief with the same complaining witness as the terroristic threat?
No, Your Honor, different complaint witnesses. Yeah. Okay, I'll be out.
Yeah, and okay. Is right now the no contact.
That was in the email, right?
Yeah.
Okay, got it.
Harold, you ready?
Report, Your Honor, yes. Just read Mr. Garcia right here. Mr. Garcia, Alberto Garcia, he came from getting tested.
Yes.
And I believe he tested positive. Cocaine and. Weed and alcohol. Cocaine, weed and alcohol. Cocaine, weed and alcohol.
Is that right, guys? Test positive cocaine?
Presumptive positive for THC, alcohol, and cocaine.
I'm now going to test you like crazy to make sure that you're not using, and then the next time you will stay with me. Do you understand? I'm giving you the ability and the opportunity now to stop on your own. And if you're unable to, then we will do it my way. And I promise you, you're not gonna like the way that I do it. Do you understand?
Understand.
You will be testing 2 times a week, so I know that you're not using it. Okay. What was the last name again?
Garcia, Alberto Garcia.
I'm also ordering you not to have contact with your sister, not to be in possession of weapons. If I find that you have contact with her, I'm issuing it. Let me make sure there's a protective order.
The paper that I have, it says that,
It does say that.
yeah, that I can be 220 feet.
It's already in his conditions, I think, but it's
What he do to his sister? Oh my God.
he's gonna be.
I don't see a protective order that.
Or maybe not that order, but if you show me.
The report identifies JV as a protected individual, not commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate or threaten or harassing behavior. You cannot be in possession of a weapon. Harold, how old is he?
21.
Where do you live?
7298 Kings Gate.
I mean, are you living with mom and dad, or
Yeah.
where do you live?
My mom.
Okay, does this person also live there as well?
Yes, but we don't have no contact, and I'll be out of work. And I finna, since I already knew about the case, that I can't be there, I'm find another place to.
I don't want to put you out on the street, okay? Where else? I'm gonna let you speak to Harold to see whether we will take off the residential restriction, okay? But I'm going to protect every person in this county, Mr. Garcia. You have to understand that your mom or whoever in your life probably doesn't have 10 to 20 grand to get you out on a bond if you violate this. So if you go to jail, you will probably be stuck like Chuck in there until this is over with. And it takes damn near 9 months just to get a 911 tape. Do you understand?
I understand, sir.
So make wise decisions because you get no more warnings from me. If he has nowhere else to go, I don't want to put him out on the street, or he can go back to the house with mom. But I just don't want him having contact with sister, you know, and I don't want you to pick up any new cases. You're on bond for felony now. They've very well revoked that bond as it is. Are you picking up this new case?
Let me talk for 2 minutes, Judge. I can.
Take your time. Just if you need it, we'll do it.
Yes, sir.
But you need to sign this order for protection before you leave. Okay? Can you file no contact, no weapons, please? Don't worry about it. He's gonna be supervised. I don't need you to do it. What?
Sorry. I just think
Get y'all, we back off air from his courtroom. Let's see what's happening over in okay, Judge Fletcher is, I think he might be done for the day, y'all. He might be done. So I'm gonna do a little bit of work today. But thank y'all for rocking out on our random docket watch day. I think we're gonna do this more often. I really enjoy just sitting in and listening in to all of the different cases in the different courtrooms. One thing about docket watching is that the judges don't always schedule their watches ahead of time, so we just kind of have to go out there and find us a feed in order to watch. So wait a minute, is he back? No, he's still out. Okay. They don't always schedule a feed for us to.
Yeah.
Good. We don't want to reset, Mr. Joseph until we get a final say from you whether or not you're going to revoke his bond on the BBR.
Say it again.
We don't want to reset, Mr. Joseph to do the TRAS thing. He's right here.
Well,
There was a PPR.
I know.
Oh.
Where he's going, he's going 4 or 5 minutes. I don't know what the deal is, Judge.
What are you doing yourself these days? Are you working?
No, I'm trying to
Yes,
find a
sir.
job
No,
now.
sir, to the judge, or no, your honor, or yes, your honor, to the judge.
When is the last time you had a job?
I never had one. I'm making an appointment to get my ID. It's kind of hard to get a job with the ankle marks on my leg.
You haven't even tried.
I've been doing job, I can show you.
What have you done?
I've been doing job applications, but I ain't never had a job, so I don't got a good resume, so.
You graduated from high school. I think the deferred is the right thing to do. You get on this probation, I'm gonna whip you up. I'm telling you now, I'm not gonna play. You will be expected to do things, and if you don't, there's a heavy price to pay if you don't. No more clowning, no more sitting on your tuchus doing nothing. We expect results. And if you just sit there and think that you're just gonna do nothing and smoke weed, it's not gonna happen, man. It's not. You're on a fast track to nowhere in this life, Mr. Johnson. This life sucks without money. It really does. You're setting yourself up for not a damn thing, just to become another statistic. You're not finished high school, not looking for a job. What do you do all day? What do you do?
And nothing to do. I've been looking for jobs. I made an appointment for my ID. I'm waiting to get an ID.
What do you have in your life that's pushing you to do anything good? Is mom and dad around?
My daddy passed, my mama, yeah.
Yes, sir, no, sir.
Yes, sir.
Mom or what?
Sir.
Do you live with mom?
I live with my girlfriend.
So the girlfriend is who works, who's pulling your, giving you everything?
Sir.
You're okay just riding and letting the girlfriend work and just.
Nah, I've been looking for a job. I've been doing job applications.
When is the last time you've had a job?
I never had one.
Okay, so you a bum. You've done nothing. How old are you now? Okay, it stops. It stops now. You understand? I'm gonna keep you all so close. You're gonna think that I'm the parental figure here, because that's what's gonna happen. Enough is enough. We need to get on this quick before this ends up nowhere real quick. So send it for the TRAS today, back on Monday, and I want it done Monday. And the first thing that we will do once that happens, 2 weeks to get an ID.
Yes, sir.
Okay?
Thank you, Your Honor.
Done. Hi, Joe.
Judge, I'm back on, Mr. Martinez, you emailed Chief Geis, I believe. Just following up on that, Your Honor.
Sorry, I haven't had a chance to listen.
No issues responded.
I just got an email saying that they're gonna follow up. So today's Monday.
Yes, sir.
Let's set it for Wednesday.
This Wednesday?
Yeah, I'll waive the appearance. So just come back. If we have an answer, great. If not, I'm gonna follow up email and then I'm gonna email like every other minute until we get a reply.
All right, good.
I will be relentless.
All right.
Mr. Tachi.
On, Mr. Delgado, Dean Delgado, just taking in on the felony warrant. Just, yeah, just want to, discuss the, bond conditions. I believe he has, the, ignition interlock. You ordered him to do that.
Give me a second.
I understand, but what I'm
Driving backwards on the shoulder of a road and he's got alcohol in the car,
Your Honor,
allegedly.
I'm not arguing any of that right now. I just want to say he no longer has the vehicle. Can we order a portable device?
Oh, yeah, absolutely. Yeah, but let him know.
Yeah, he understands. I talked to him
Yeah,
about that
absolutely,
already.
of course.
Okay, I'm not arguing any of that just yet. Not yet. We'll wait to see, but I appreciate you. Thank you.
I do have an update on that active situation outside. It seems clear, there's a deputy that's being transported.
No.
To medical attention. I don't know why, as well as, someone.
They got us, who? They got a suspect? Was,
Suspect also being transported. I got those.
so it was a shooting.
That's what I understand. They don't have much information out there investigating it, but it is secured.
Harold, I'm sorry, hold on a second. Abel, you've been waiting a long time. I'm sorry. So next time, just yell, man. I always forget. I've got so many windows open that I forget.
No worries, Judge.
Okay, what you got, bud?
I have Mr. Benavides, Irving Benavides. It was a bond forfeiture from a couple of years ago. He just popped back up on the radar. I was.
I can always tell how old it is by what the bond I said, you know? What do you want?
I wasn't aware of it this morning, or else I would have addressed it when I was there this morning. But I was requesting a short reset.
Yeah,
I'll
for sure.
for it to be rolled to tomorrow, so I can get my ducks in a row.
Guys.
But I was told it was very busy tomorrow.
So, Mr. Benavides, I don't know if he's gonna bond out, but if he does, GPS prior to release, please. No weapons, no drugs, no alcohol, no contact with the complaining witness. You tell me what you want, Abel. I'm putting a
Judge,
monitor on him if he takes off, or if he gets a
It's up
bond,
to
bonds out.
I mean, whenever Victoria thinks we should bring him back, I'm fine with that. But he has been
Give
missing
me a
in
second,
action
I'll get a date for you. Hold on.
for a good while.
All right, got it. Should you need me, Judge?
Yeah.
On video?
Benavides, we need a date.
How much time?
You want a week, a day, a weekday?
Up to the court, Judge. I'm there
I
tomorrow.
don't care. I can do a week.
April 30th.
April 30th?
I'll be there.
All
Done.
right, got it.
Thank you.
Thanks. Ms. Penman.
Hey, Judge. I just wanted to follow up on Palacio. He got sent for the drug test today. He did just text me and said they just called him up to do the drug test, so he should be back over.
So we'll roll it. It's already nearly 1 o'clock. Let's roll it till tomorrow. Because by the
Okay.
time we get him, okay?
Okay, and you want him there again tomorrow?
Yep.
Okay, I will let
Thanks.
him know. Yeah, I just wanted to check in.
Yeah.
Okay, thanks.
Bye. See you tomorrow. Harold.
Judge, Mr. Garcia, these cases are both almost a year old, like June, July of last year. He's been living with his sister, his mom, ever since this happened way back when. I guess she called the police, reported it, so it's not a current thing with him. I know it's a serious charge.
Okay,
but-
so I'm okay with it then. I'm okay with him going back. We'll do no threatening, no harassing with sister. Okay, my main concern is the other drugs though, right? That I don't want him using. And I don't know if that contributed to or was a factor of, So he can go back. We'll take off the residential restriction, no threatening, harassing, and then just no using. And then, but we'll have to test him a lot to make sure he's not using, and that's it. Whatever day you want. Or actually, we'll see him on Thursday to make sure he's not using.
Sure, I think I'll be,
You can always Zoom, remember.
Judge, may I interject? Was this on O'Neill?
it was like,
Everyone-
Garcia.
Just making
Garcia.
sure.
And then I have one more to ask you about, Judge. Mr. O'Neill, he's a new case that we have. Michael O'Neill. Prosecutors have been working on this. I think they just made the rip call. He's been out of his house for,
Oh, right.
I think a week. And the kid's his elderly father, who's like 80, and he has some kind of dementia problem where he wanders out and they can't find him. His mom was also there, but they both had strokes not too long ago at the same time.
My issue is with the complaining witness, though. Does the complaining witness live there? Is she in fear of him? Is she okay with him going back? If she is, I would be too. But I want to follow what she wishes, like what she wants, because she's obviously a resident of the house as well. And have you had a chance to contact her?
Yes, Judge, I just spoke with her.
And
A little bit of context to the situation, the defendant is her father.
come up. O'Neill, no, O'Neill. Hold on, let me, so you can hear this.
Bridge stuff.
Okay. My sole issue is protecting as many people as I can. That's what I want to do. I know, or it may come at an inconvenience to you, but I like to follow the wishes of the complaining witnesses. Because I don't want them to live in fear. There's nothing worse than having to live in fear, having to walk on eggshells. And that's what we try to prevent here. And I know that you have your side of the story, and there's always two sides of the story, but the best recipe that I usually find is keeping people away from themselves. The problem is that may be a disadvantage of you because you may have nowhere else to go. But what other choice do I have? I don't know, right? Tell me, you were able to speak to her.
Yes, Your Honor, and I'll relay the message she gave me. So just a little bit of context, the defendant is her father, is what she says. And she says she's had no contact with him since the incident. But she does say she's been getting updates from family about the defendant that she's not asking for. She said that she's getting married and planning on starting a family, and her heart's desire is to have her father in her life, but she said that he's proven that it cannot happen. She states that she is done with her relationship with the defendant. The defendant has not changed. She wants no contact. She's currently working on making her restraining order permanent. She states that the defendant is not trying to get help. She states that she wants anger management, Alcoholics Anonymous, and Narcotics Anonymous treatment.
So there's drug issues and alcohol issues.
According to the complaining witness, Your Honor, yes. So we know about the situation.
Stop. Don't say anything. Just don't.
And so we know about the situation where he needs some of the items he has at his place. She says that she has them placed in bags. She says that she's either told the family to handle giving the items to the defendant, or she is okay if the defendant comes with officers while she's not present.
So she obviously lives at that house?
Yes, Your Honor.
Who, is it grandfather's house? Whose house?
I'm not sure.
I mean.
It holds the grandpa's house, his father's house. But he had actually moved in there to help out with his parents and, well, I told you, he had strokes at both times. Right?
Yeah, but I can't, she's living there and, it's.
So I'm told that his daughter is a drug user, Judge, and that this happened late at night. In fact, even in the DIMS, it says that this alleged assault.
I can't really,
Oh, no, but it says alleged assault happened at 2:30, but we didn't call the police until 4, I believe. And she mentions a long gun, but there was no guns found at the scene.
I don't know. I just don't want you to, she doesn't want to have contact with you. So don't have contact with her. Don't use any drugs, don't use alcohol, and making that a condition of your bond as well. I don't know what to tell you, but she lives there. And if I allow you to go back to that house, it's a recipe for disaster. you know?
Judge, he does live with his parents and does nowhere else to stay right now. He's been living at the Star Hope Shelter for a week. In fact, they arrested him in his underclothes and he's wearing clothes that are given to him.
Well, I mean, like you said, he can go back and get the stuff. He's got to go with an officer. And at a time that she's not going to be there, I guess we could work that out.
His ID and cell phone, all that are at the house and they can't
I mean, she has it in bags ready to give to him. You know what? Also do this. Can you, well, let's, if you want to, we can roll this to tomorrow, but will you also reach out to, I guess, the homeowner and get their opinion? Are they okay with him coming back? Perhaps you can get their side as well and see what they say. So we get like a neutral and detached person to see, is this because he obviously wants to go back to the house? What are, I mean, we know that she doesn't, but the problem is that if I let you go back to this house, you will invariably at one point or the other, you're going to run into her. And it's going to be disastrous because it always is. And then you're going to end up back in jail. You're out because we gave you a free bond right now. You need to understand that if you go back, you probably have no one in this world that's going to pony up 5,000 to 10,000 to get you out. You will be stuck like Chuck. You need to consider these things when you're out there. I'm not asking much from you. I just don't want you to have contact with this person and don't have any weapons and don't use. That's all I'm asking. You want to roll this tomorrow to see if there is perhaps a way that they could kind of separate, kind of bifurcate the house, so to speak?
Again, is your father able to answer the call if they call and talk to him?
No. Well, look, I don't want you guys to talk here. Let's do this. Let's roll it to tomorrow. See, do you mind reaching out? Is there a possible way to kind of divide the house in half or is there like a garage apartment or is there like a shed or something that he could stay at? I don't know, you know, but
That's how I've been.
You're separate from her.
Yeah, I'm separate from all of them.
We can talk about, he's telling me that he's separate, living away from everybody, his own room, I guess.
I want to hear it from them too. I don't want to hear it just from you. I want to hear it from them that they feel protected. That's my
understand.
You know?
I understand.
So we can, you know, come back tomorrow because it's already 1 o'clock, right?
What time tomorrow?
Same time, early, 8, 9 o'clock. So
We'll be here tomorrow.
So guys, this is Mr. O'Neill. So no contact, no weapons, no going to the house for the time being, no drugs, no alcohol, random testing, please. All right, Mr. O'Neill.
Testing.
No drugs, no alcohol, and I'm going to test you to make sure you're not using. If you test positive for drugs or alcohol, I'm going to put you in jail. Don't use.
Yes, sir.
All right. Okay. All right. Good luck, Mr. O'Neill.
Thank you, Judge, no excuse.
Thank you.
Martha?
You better come have a seat for me, your daddy. Well, you have a seat and I'll call you whenever they're ready.
Come on.
Page 10, Curtis with no PC. Are we expecting a no on that one?
So you bring it through next Monday for the last Monday of the month.
Okay. The lady is gonna. Condition this and this.
Figure out 255.
Right, Judge, page 19, fines. I was told we were expecting dismissals on those.
What say you guys?
Yeah, that's the one that claims
Rupert said he emailed y'all.
Yeah. Then, yeah, I'm going for it now.
Okay.
Yeah, make sure you have it. So,
I'm going for it now, Judge.
Next, judge is page 20, Irving. F4 Raymond goes to here, 2 bonds posted.
5,002.
CO,
Yep,
let me know when you're ready.
thanks. Okay, I'm ready.
Page 24, Martinez. I saw Joe was in line. I don't know what.
I think we rolled it 2 days.
Today,
Yeah, because we're still waiting on a,
response.
yeah.
Okay, next goes is page 28, Melbar. I was told the supervision order was coming our way.
I have one on Mariana Odiambo. I have a supervision order, just so you know.
Yes, there needs to be 2. So far, only one. Without counsel.
Sorry.
No worries. Yes.
Yes.
Yep, I gave them the reset already. So we'll be done right
Are you ready?
now.
We're doing your plea? Yeah, okay.
Judge said Monday, Thursday, testing, so I'll put them on the list. Judge page 31, Ortiz. No PC was found.
Is it your seal?
Alan.
Good afternoon, Your Honor. Real quick, I'm approaching on behalf of Chaston Black. This is off docket. I can give you the calls number.
Okay, what is it?
254-0799.
Yes.
Yeah, so I filed a motion to restore property today. The case was dismissed back in, I believe, in March. It may be it may be beginning of April as well.
Okay. Are you around tomorrow?
Yes, Your Honor.
Okay, come by so you can get with the state to see what their opinion is, whether they're opposed or unopposed.
Sounds good. Thank you, Your Honor.
Okay.
Page 34, Price, is that for Raymond Council Field Church?
2501.
Page 35.
Both?
Well, Robinson, a bond was posted. I can take a look at the date. I think it's at 5/23 there. So I was gonna call the defendant and give.
Okay, let me know.
That's an issue, but page 35 and 36, Rodriguez.
2501 each.
Page 38, Walker, 2 bonds posted.
5,002. I'm doing a BO.
Okay.
Okay, Vic. Who's next?
Judge, that was the
That's it?
last one. We have Lane, there's Kitty, and that's it.
Okay, ready? You ready? You mind bringing out Lane? Thanks.
You said today's? Okay.
Yeah, that's supposed to be 5,003. Yeah, it's supposed to be 5,003.
Ain't on lane, Judge, we just go slowly through.
For sure, of course.
I haven't set the. Oh, wait, let me see.
Darío.
That was, gentleman that was in custody, well, let's get this out together.
I'll raise it, Judge. It looks like. I'll raise it by that.
Explain Comcast is.
That's right.
You're pretty nice. Let's see. Go ahead and sign on his head, I think. Here, let's see. Mr. Lynn, can I get your right thumb on the blue light, center of the blue light, press down and hold? Great.
Good morning, Mr. Lane.
Good morning.
You were charged with 4 counts of assault.
Fifth, Judge.
I'm sorry. Theft. 4 counts of theft. You have worked out an agreement that you're pleading guilty to one of those. It is 165 days in jail, but we will give you credit for the 55 days that you've done, so there's no more jail time. But this will go on your record. It will be there forever. You now have at least 2. So if you ever pick up another theft, you will be charged with a felony. Do you understand?
Yes, sir.
If they charge you with a felony, you will be looking at years instead of days. So I wouldn't do this again because you're looking at a lot of time. Do you understand?
I understand.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it goes on your record. You can never take it off. Do you understand?
I understand.
Where are you going when you leave here?
I'm going to start a bridge or to Spirit Key or Bridge of Muddy Waters.
You have family that's around?
Yeah, I have family. They live in Hunters Glen 3. My dad lived.
To them.
Being an older person, I was always doing everything on my own. I go for them for resources.
If you want any help, come back here and we can help you with things. We can give you, a cell phone, tablet, place to stay, food. If you have family, perhaps they'll take you back in so you don't wander the streets. Nothing good happens on the streets. Do you understand? How do you plead to the theft? Guilty or not guilty?
Guilty.
I'm gonna find you guilty. I'm gonna follow the agreement. Good luck to you, sir.
Thank you, Judge.
Okay, Mr. Lane. Really? Really?
I know there's a lot of administrative stuff that you have to do.
We always do.
I appreciate it as always.
Thanks.
Thank you.
Judge, did you want 5,000 for your all mistakes?
No, just on the DWI and the FSGI.
Okay.
Yes.
And you terrorist threat that can stay at 1501?
Uh-huh.
The terrorist threat can stay.
Just leave it. Yeah, leave it at 15. Okay, are you ready? Are we done?
Yes, Judge, I'm putting, order of appointments in there for you to sign and I'll take this little. We get all our dismissals for Lane.
Did you put all the dismissals for Lane by chance?
Not right now, Judge.
Okay, all right, guys, we're done.
Can I get a signature on like your pen?
Yeah.
Okay.
Well, Judge, can you sign one of the bonds just for sure?
Yeah.
Can I have another one for Collins?
It's just life.
Okay, I think I've signed everything.
Put two more dismissals in. I got comments. And then I call the one. Yeah. Yeah. Yeah, we got making off.
All right, that's it.
All right, y'all. I'm gonna go ahead and end it up for the day. I will see y'all tomorrow. We will be watching Karen Reed. I will update the stream so that we know what time we're gonna start. And I'm excited. So I'm gonna see y'all then. I hope you have a good night or good day. See you.